Recording of the meeting has started.
Chair LaHood, do you want to introduce the meeting?
Yes, one moment, please. This is the Sunshine Ordinance Task Force Compliance and Amendments Committee meeting for the City and County of San Francisco. It is August 23rd, 2022 at 4:35 p.m. This is a remote meeting via video conference. Public comment call-in number is 1415-655-0001. The meeting ID is 2482965-2968 #. Press *3 to enter the speaker line. Remote access to information and participation. In accordance with Governor Newsom's Executive Order number N3320 declaring a state of emergency regarding the COVID-19 outbreak, and Mayor London N. Breed's proclamation declaring a local emergency issued on February 25th, 2020, including the guidance for gatherings issued by the San Francisco Department of Public Health Officer, aggressive directives were issued to reduce the spread of COVID-19. On March 17, 2020, the Board of Supervisors authorized their board and committee meetings to convene remotely via Microsoft Teams and will allow remote public comment via video conference. Members of the public may participate by phone or may submit their comments by email to cheryl.leger@sfgov.org. All comments received will be made a part of the official record. Sunshine Ordinance Task Force agendas and their associated documents are available at sfbos.org/sunshine. As the COVID-19 disease progresses, please visit the Sunshine Ordinance Task Force website regularly to be updated on the current situation as it affects the legislative process. Meeting decorum. Any member of the Sunshine Ordinance Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Ms. Leger, please call the first item.
Item number 1, call to order, roll call and agenda changes. Roll call. Member Neighbors.
Present.
Member Neighbors present. Member Wong.
Present.
Member Wong present. Chair LaHood.
Present.
Chair LaHood present. We have a quorum. Members, are you aware of any agenda changes? I am not.
I'm not aware of any agenda changes, but we had a request to include a break. Was that a request for a break after the item number 6?
Yes, that's what I was thinking. We have 1, 2, 3, 4, 6 cases on the agenda. It just seemed like a good dividing point, unless the members of the committee feel elsewise that we should have a different point of break.
Let's see how things go. If we are moving rather fast, we might move the break further along. But at this point, if we're on a typical pace, that does look like a good time to take a perhaps a 10-minute break.
All right. Okay. Item number 2. Are we ready for item number 2?
Members, any other comments? Okay, great. Please call the next item.
Item number 2, approval of the June 28, 2022 Compliance and Amendments Committee meeting minutes. Members, I have a copy of the minutes right here. Any suggested changes or corrections? I was looking at the minutes. I'm sorry. Did I miss somebody's correction?
Members, do we have any comments or corrections on the minutes, or should we open this up for public comment? Okay, Mr. Young, we'd like to open up for public comment on the minutes from June 28th, 2022. For anyone who would like to make public comment, please press *3 to enter the speaker line, and Mr. Young will let you know when you may comment. And Ms. Leger will let you know when she's ready with the timer.
Yes, at this time, if you'd like to make public comment, you can press *3 to raise your hand, or otherwise raise your hand through the application. I did have a hand raised from our previous item. I don't know if they wanted to comment on that, but I will go ahead and unmute them and get their comments at this time. I will go ahead and unmute our only hand that is raised.
Sullivan. I have a comment on item 1.
Okay.
Mr. Sullivan, this is for comment on the meeting minutes.
Yeah, but you didn't take comments for item 1, and I had my hand raised as Mr. Young told you. And this is it's kind of important to the agenda.
Okay, I will allow it. Go ahead.
Okay. On agenda item 7 was first heard at the January 11th, 2022 Education and Outreach and Training Committee. The agenda of the meeting is in the packet. The minutes or any record of what happened at that meeting and referral to the Compliance and Amendment Committee are missing from the item 7 packet. Agenda item 8 is missing an email. I clearly marked subject line for SOTF complaint file 21069 and sent on July 29, 2022 and contains a complaint of over-redacting and junk responsive records to this record request with examples like commercial ads. Maybe this was given a new file, number 22091, part of an email on August 12, 2022. Ms. Ledger states, in addition, I received an email from Mr. Sullivan, but he forgot to tell me who the court respondent was. And then she says file 2091. Mr. Sullivan just let me know. I can't connect this file number to anything as I have never seen it or associated with the complaint. I responded to Ms. Ledger with some of this information that I stated on August 12, 2022. Thank you for your time.
Hi, this is Victor Young. I believe that we should just wait until we get to those items before we consider it. It's not an agenda change as far as I can tell.
Mr. Young, I was thinking the same thing. I understand why Mr. Sullivan thought he should bring it up at agenda changes, but it's not really an agenda change. But when we get to those items, we'll give Mr. Sullivan a chance to, one of our committee members will be leading those two cases, and we'll have a chance to discuss if there are any issues with what was included in the packet and whether we are able to proceed with our discussion today. So we will get to those later. Are there any other comments on, again, we're looking for comments on the minutes from June 28, 2022. Is there anyone else in the queue who would like to make public comment on approval of the June 28, 2022 minutes?
I do not see any additional hands raised at this time for public comment on the meeting minutes.
Okay. May I have a motion to approve the minutes?
This is Member Wong, so moved.
Is there a second?
I second. Member Neighbors.
Okay. Mrs. J, please call roll.
Okay, just a second. Member Wong?
Aye.
Member Wong, aye. Member Neighbors?
Aye.
Member Neighbors, aye. Chair LaHood?
Aye.
Chair LaHood, aye. Moved by Member Wong, seconded by Member Neighbors to approve the June 28, 2022 Compliance and Amendments Committee meeting minutes.
Okay, thank you. Please call the next item.
Okay, just a second. Sorry, I just need a minute to look myself. Okay. Item number 3, public comment. Members of the public may address the committee on matters that are within the committee's jurisdiction, but not on today's agenda.
Okay, once again, if you would like to make public comment on items not on today's agenda, you can press *3 to enter the queue, and Mr. Young will let you know when it is your turn, and Ms. Leger will let you know when she's ready with the timer. Mr. Young, do we have anyone in the queue to make public comment today?
Yes, we do have several. Just clarification, if you'd like to make public comment this time, you press *3 to raise your hand, or otherwise use the application to raise your hand. I will start. Cheryl, whenever you're ready, please let me know and I'll unmute our first caller.
Yeah, unmute the first caller, please.
Sullivan.
Mr. Sullivan, are you ready?
Yes.
Go ahead, sir.
I apologize for the first comment. Okay, at the last full task force meeting, I was having difficulty with my mic, so I do not think the beginning of what I said was clear. I agree with Chair LaHood that notices for special meetings should be given to anyone who asks. An email list out is not that hard, easier than what is going on now. Full and committee meetings are easy to keep track of since they are on the calendar. Special meetings are less so. I am not interested in retaliation. In order to change the current state of just continuing to spin on the hamster wheel and not going forward, holding people accountable for willful violation is a must. No accountability or ignoring the root causes of the problem just allow for repeat. Court judgments are not an enforcement. Courts are good when there are known records being withheld or there's dispute on what the law says. It only takes seconds for a law to be violated, but accountability and rectifying a wrong takes a lot more time. An official saying someone can take the personal decision they made to court is dismissive, especially since that official's money is not on the line nor the consequences. When the city goes to court, they have the deep pockets of all our money, the taxpayers. Win or lose, there's little risk or consequence for violation for an official. It is only when bodies can remove, fine, censure, or make facts public that there can be consequences. If a procedure does not exist, then the likely outcome in court is the court ordering a body to follow the law and come up with a procedure. And you're back to square one. Thank you for your time.
Thank you, Mr. Sullivan. Mr. Young, is there anyone else in the queue?
Yes, there is. I am unmuting next. Hello?
Yes, we can hear you.
Oh, sorry. This is Jeffrey Greer. I was just testing the WebEx system to make sure it works. That's my public comment. I'll be logging on later. Thank you.
Yes, you can press *3 again to lower your hand. Moving on to the next one.
WebEx. I'm on WebEx.
He's on WebEx.
Yes, you can either way, somehow lower your hand again. Thank you very much.
I think I did it. Okay.
Yes, you did.
Is there anyone else in the queue to make general public comment?
I have unmuted.
Yes, my name is Tillian. I would like to make a suggestions to the. Oh, should I wait until?
Actually, wait one moment. Wait one moment. Ms. Leger will tell you when she's ready with the timer. Thank you.
Great.
You ready, Mr. Bazansky?
I'm ready.
Go ahead, sir.
I would like to make a suggestion to the Sunshine Task Force complaint submission process. As far as I understand, the Sunshine Ordinance Task Force is not the only public body or organization that helps with enforcement power under California Public Records Act. The superior courts may also help with enforcement when it comes to California Public Records Act, and it's my assumption that Sunshine Ordinance Task Force is faster and more democratic. However, I was proved wrong. I remember back in late 2020 when I first contacted Sunshine Task Force, I was told that there was like 9 months backlog due to COVID. In comparison, the average time to trial in the most California courts is about 1 year. So if I'm a petitioner, I might prefer to submit the complaint via San Francisco Superior Court and might get resolved faster than the Sunshine Ordinance Task Force enforcement efforts. For that reason, I'm suggesting to have some kind of red bar on the Sunshine Task Force websites that says what's the current logback time. For example, due to monkeypox, the current delay time is about 10 months. Thank you.
Thank you for your comments. Mr. Young, is there anyone else in the queue?
That completes our queue for public comment.
Okay, thank you everyone for your comments. Ms. Leger, please call the next item.
Hang on a second. Item number 4, file number 21124, hearing on the status of the order of determination complaint. Complaint filed by Mark Norton against the Department of Public Health for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and or complete manner. On April 6, 2022, the Sunshine Ordinance Task Force found that the Department of Public Health violated Public Records Act 6253 B as in boy by failing to make records promptly available to any person upon payment of fees covering direct costs of duplication, and 6253 C as in cat by failing to respond within 10 days from receipt of the request with a determination on whether the public records are disclosable, and Administrative Code Section 6726 by failing to key by footnote the redactions and failing to provide additional Giants records.
Okay, first let's determine, do we have the petitioner here?
If you are a party to this matter, if you can go ahead and raise your hand at this time by pressing *3, or otherwise using the application to raise your hand, it would be appreciated. I will unmute them at this time.
Okay, so we're looking for the petitioner and the respondent. We want to make sure that everyone's here before we get started.
I have unmuted 2 parties. Hopefully they are. If you can go ahead and announce your name and your...
Let's start with the petitioner.
Hi, this is Mark Norton. I'm the petitioner. Can you hear me?
Yes, we can hear you, Mr. Norton. And
Thank you.
who is here from the Department of Public Health?
It's Allison Hawks from the Department of Public Health.
Ms. Hawks, thank you for being here today. So this is a hearing on the complaint and to...
It's a hearing on the OD.
Excuse me. It's a hearing on the order of determination. Thank you. So I would like to give Mr. Norton just a few brief minutes to give us an update, and then I'd like to give Ms. Hawks a few moments to give an update. Actually, I am going to ask Member Wong. You wanted to say something about this. I think you were going to lead questioning on this case. Would you like to say something first?
Yeah, I just wanted to say briefly that I wanted to let Mr. Norton know that we did receive his email via Cheryl, but we didn't, that email and letter did not get added to the agenda because it was submitted after. And so I would love for, in those minutes that we're giving to Mr. Norton to comment, I would love for him to cover that letter as well.
If you could summarize what he intended to say.
Ladies, just a moment, please. Did we want to time these comments?
No, since this is about compliance, I don't feel compelled to time, but I do ask both parties to be concise in their comments so that we could move on with questioning. So, Mr. Norton, I'll give you a few minutes first. We're not going to time you, but we ask you to please be concise with your remarks.
Okay. I am assuming that the letter you referred to was the updated statement that I submitted yesterday morning, and that I assume that the committee actually has a copy of it, even if it's not in the official record. Am I correct about that?
That is correct.
Okay, great. So here's the deal. This is the third proceeding that has happened with the Sunshine Ordinance Task Force on these matters. There was way back in November of 2021, there was a committee hearing for the Education Committee. They found violations. That was submitted to the full Ordinance Task Force in April. They found violations. It's now August. And the Department of Public Health has responded to all of the requests that have been made in the past by the task force members by doing nothing. The key thing here is that when I made the request for the documents, they clearly selectively picked and chose what they wanted to release and didn't release what they didn't want to release, clearly leaving out the most important documents, and very specifically that the Giants had asked in May of 2021 to dump all of the COVID restrictions at the ballpark. Clearly, the DPH responded to that, but none of the documents that have been released show their response. They clearly weren't timely in their response. I had to file this this complaint before they even did anything, even responded to me, even noticed that I had filed a request. They've never provided a usable index of any of these documents. They have no explanation for the redactions that they've made. When are there consequences? I confess I don't fully understand the procedures of the Sunshine Ordinance Task Force. I understand this is today is about an order of determination, but I don't really understand what that is. Haven't been a copy of it. I don't know what that's about. But the real question here is DPH has not released the documents. This is the fundamental question. They have not released the documents that I requested. And I'm really asking you guys, when are there consequences for DPH thumbing their noses at me and at the Sunshine Ordinance Task Force? Thank you.
Mr. Norton, thank you. I'd like to give Ms. Hawks a chance to speak for a few minutes. Then I'm going to hand things over to Member Wong, who I think might be able to answer some of the specific questions you asked. Although I do want to say that when we have a hearing with the full task force and we make we find a violation, the text of our violation, or excuse me, the text of our order that is handled in the meeting is effective immediately. So even if you have not received a formal write-up that is the order of determination, what we determine in our full task force meetings is considered an order of determination, and that's what we're responding to today. Ms. Hawks, if you would like to speak for a few moments, you may respond to things that Mr. Norton said, or tell us a little bit about how the department has complied with our order of determination.
Thank you. I will just go briefly over the history here. There's a long history of correspondence with Mr. Norton on these records. I will try not to take too much time, but just dating back to April 12th, 2021, we received his request, and then we immediately on the 21st, our custodian of record contacted Mr. Norton and asked him to narrow his request down so we could identify and produce responsive documents. Mr. Norton declined to narrow his request. And then on July 1st, we contacted Mr. Norton and stated that we were working on identifying the responsive records, and could he refer to several files for responsive records related to the Golden State Warriors. On September 16th, through the Sunshine Ordinance Task Force, Mr. Norton followed up on his request. DPH conducted a search, and on September 25th provided 41 emails and 24 documents as responsive records. And this was done through our new custodian of records at the time. Mr. Norton then inquired about additional documents related to Oracle Park. DPH then went back to the DPH subject matter experts to inquire after additional records. And after conducting further search for records, the subject matter expert, DPH, uploaded 63 additional records on October 9th, 2021. So there's a history here of responding, perhaps not in as timely a manner as he would like, but there was plenty of correspondence over the past year with Mr. Norton in attempts to try to get him materials that he was asking for. The last time this was heard was on January 27th, 2022, and at the request of the Sunshine Ordinance Task Force, DPH uploaded a document index of the responsive records. As I recall, back in January, there was a request that we produce an index of the responsive records, and we did that. We provided that with the task force. To date, DPH has provided more than 100 responsive records to Mr. Norton, which included plans, emails, other documents. And I do have to say we have not identified any additional responsive records to provide at this time. So, I mean, DPH acknowledges that we did not respond to this request in a timely manner due to staffing shortages, volume of public records requests that we were receiving, and the ongoing COVID emergency response. You all have heard kind of this explanation before, and this is a request from last year. However, our response up to the present time is complete, and we consider this request completed. We have no additional responsive records to offer Mr. Norton. Thank you.
Thank you, Ms. Hawks. Member Wong, I know you took a close look at this case. I'd like to hand questioning over to you at this moment.
Sure, yeah. I guess I'll start by saying to answer Mr. Norton's question about consequences, I do want to specify that the Sunshine Ordinance Task Force is unfortunately not an enforcement body. We tend to pass on our enforcement after rulings to other bodies such as the Ethics Commission. So that sort of relief comes from other places. As Mr. Stillian mentioned as well earlier in public comment, Superior Court is another option. I'm not saying that is where I'm trying to pass you off currently. I just wanted to let you know and answer your question there. But I do have a series of questions for Ms. Hawks, the first of which there were several specific things requested during our April, I think our April hearing in April 2022, the full task force, actually. There are a few things we requested. First off was a request for any records specifically relating to the Giants up until April 2021 when Mr. Norton's request was made. Number two, we were looking for a keyed redactions, which I still don't personally see in the packet. So I'm curious if either of those things, if a search of either of those things were done. He also specifically, Mr. Norton was specifically looking for, I think, an email response, which it was a response to, I believe, Oracle Park, in which DPH had agreed to follow up on our request for guidance on COVID restrictions. And I think that email was sent, I want to say in May 2021. So it's technically after this request, but that was something specifically we were looking for as well.
I'm sorry, should I respond to that?
Yeah, that would be great.
Okay. So yeah, the May 2021 was not part of the records request. And so we are required to respond to what is in the records request, and that is what we're doing. As to the other one, records specifically related to Giants up till April 2021, we provided that. As I've said multiple times, like, we've given over everything that we have. And there are over 100 responsive records that we provided to Mr. Norton. So I'm sorry, we just don't have, we've done a search, we do not have anything additional to provide that with him. And then in terms of key redactions, I believe there may have been redacted documents. I don't have a record in my notes right now of redacted documents. I do remember that there was a request for an index of responsive records, and we did provide that.
Okay.
So if you could elaborate on key redactions, on what that was, just so I understand more about that, and I can take that back to the team.
Sure. Yeah. So anytime a redaction is made from a document that is provided, a reason for that redaction needs to be listed along with that redaction specifically. So essentially creating like a key of reasons for that redaction, or for any redactions that are being made in these documents. So it's different and separate from an index of records.
I see. Was the index of records something you also requested? Because I do remember that one.
It is, and I actually did not see that in our packet either.
Okay, that was uploaded to the Sunshine Ordinance Task Force. That's what I've been told. On January 27th, we uploaded that. So maybe it's good to research that. As for key redactions, I will double check, but it's my understanding that, we do not need to provide a reason for the redactions. But I will double check on that. And maybe that is why we didn't provide it. Is the guidance that we received is that the Sunshine Ordinance does not require a listing of reasons why documents are redacted.
So actually that was part of our order of determination. So there was a violation found of section 6726 by failing to key by footnote the redactions. So it definitely was ordered in April 6th of 2022 when we last met. And I will mention also that during that April hearing, the index of records was still missing as far as the task force and Mr. Norton are concerned. So I don't think it was received in January because we're still looking for it in April.
May I ask, this is Chair LaHood, Ms. Leger, are you able to check in your email in January? Ms. Hawks, you said that index of records was sent in January of this year?
Yeah, January 27th, 2022. That's my record.
And that was sent to the main Sunshine Ordinance Task Force email address?
I believe so. Yeah, I believe so.
And it was sent what, in April?
No, January 27th, 2022. And while Ms. Leger is looking, Member Wong, if you want to continue your questioning, please go ahead.
Sure, yeah. A question actually for Mr. Norton. I think when I was listening back to the April hearing, Ms. Tran and Ms. Hawks suggested a follow-up, actually, complaints or requests for any documents following the April 2021 requests. And I was curious if you were able to make those requests and or if you've received any response for those.
I have not made any new request. Would you like me to explain why?
Sure, go ahead.
So the argument was created during the April hearing, never heard it before then, that somehow my request only covered records up through the date that I had initially made the request. The fact is that there was, as has been said to you guys, there was considerable communication afterwards, not so much documents released, but considerable communication. And, the date of my request kept going, forward and forward and forward by months. So I don't really understand the argument that this thing ends in April. But even if it did, it's clear that that has not been the consistent attitude of DPH. The very email that is indicated there's clearly things missing is dated May the 5th, which is obviously after April. And that's the one that's got a copy of an email from the Giants to DPH saying we want to dump all the COVID requirements, and DPH saying we're going to follow up next week and give you a response. That's May 5th. They gave that to me. They released it, but it's after April. They released other emails, not a lot, but a couple of other emails that go all the way through August of 2021. So once again, it's clear that they are selectively releasing records. They're picking and choosing what they want to release. It's clear that they must have had some kind of follow-up to the Giants' request because all the COVID mandates disappeared. So there must have been some, acknowledgement of that and hopefully an explanation for it. That's really what I've been seeking all along. Why is it that they relaxed all of the mandates at that point? Was it political pressure or was it scientific-based decision? I think we all know the answer, but I'd like to see it documented. So, yes, there's no index, no usable index. There's no explanation for redactions, but key here is they dumped the COVID requirements. They won't release the document that says that they did that, much less why they did that.
Okay, thank you, Mr. Yeah, so I would say in the interest of facilitation of this file, I'm curious, Ms. Hawks, given that your team has released records that go beyond April, I hate to ask again, given, it's been several months now, but I don't know if your team could specifically look for a response to that email. I imagine it exists somewhere. I don't know how, when you've said there will be a response, that there wouldn't be one. And I understand, the request doesn't go beyond April 2021, but just again, as your team has already given records beyond that date, I don't know if that's something that you all could do.
Yeah, I mean, I'm not sure which email we're even talking about, to be honest with you. And I'm not, the history here of releasing records after April, I would need to review the files and understand what those were and why that occurred. I mean, honestly, I don't see a reason just in terms of the ordinance itself for us to go back and like pick out emails after April and send them in. This would have to be a records request that we would comply with, and I would prefer to stick with what the requirements are in the ordinance rather than kind of opening up to, requests for specific emails at different points in time. So I guess that's to say I'd have to review all of this information that you're giving me, and even then, it doesn't seem like there's a precedent here or requirement in the ordinance to release records after the date of the request.
Members, I'm going to jump in here. I do want to make sure that, so first of all, we hope that departments will respond to records requests when they come in. We need to be clear that when there's an order of determination made, it applies to the original request. It can't be something that is applied going forward, or excuse me, when we have an order of determination that says certain things must be complied with, we expect those behaviors to continue going forward, but we can't expect that our monitoring of the case goes beyond the initial request. So I want to be clear with Mr. Norton that what we're trying to do here today is make sure that the order of determination and the original records that were requested in the request that that were related to your original complaint, that we have compliance there. As far as information that you're seeking beyond that, you may request, you may make new additional requests beyond that date. If you have any problems with requests made beyond that date, you are welcome to come back to the Sunshine Ordinance Task Force, but we can't conflate all of this together. And I just want to make sure that today we're discussing records that were part of the original request that the order of determination pertains to.
May I speak?
Yes, please go ahead.
Well, the task force has already conflated it long before I did. At the November 2021 hearing of the Education Outreach and Training Committee, Chair Hyland, if you look at the minutes, specifically requested an index of records for the time period from May 1st, 2021 through November 9th, 2021. That was the date of that committee hearing, and for documents relating to the Oracle Park request. So, when I heard that back in November of last year, I assumed that meant something. Now you guys are telling me it doesn't mean anything. And that the DPH is free to pick and choose what they want to release. And specifically to hide from the public and the Sunshine Ordinance Task Force why they relaxed the COVID requirements of the ballpark. Sure, I can go back. I can make a new request specifically for the response to that specific email, and then we'll be sitting here in another 16 months talking about why they haven't given it to me. That's the game that DPH is playing. Thank you.
Unfortunately, I think there was definitely confusion at the EOTC committee meeting that was hearing this complaint. I think it was clarified at the full task force meeting, and very specific things were being requested, which are any records that were made on or before the date of the request, which was in April 2021. Again, for that index of records, and then also for any keyed redactions. So these are definitely the things that we're most interested in looking for compliance of today. So I'm curious, Ms. Leger, were you able to find that index of records?
I didn't find anything from Public Health on February 7. I looked in both my task force directory and my personal email directory. I checked the history. I have a history of emails that come in when I'm no longer working on them, and I checked that. I also checked my deleted emails. I checked my directory for the specific case. I didn't see it, so.
Ms. Lejay, I'm hoping you were looking at a range because I believe the date that was stated was January 27th.
I thought you said February 7th.
Ms. Hawks, did you say January 27th?
Yeah, yes, I did.
All right.
And it also sounded like Mr. Norton had already received it based on what he said.
Mr. Norton, did you receive the index of records?
Okay, can you hear me? Can you hear me now?
Sorry, this is Chair LaHood.
No, they released an index on October 27th, totally unusable. Here's the returns to the ballpark. Here's the index: 1, redacted PDF; 2, redacted PDF; 3, redacted PDF. That's how it goes on and on. Whereas for the Chase Stadium, the Golden State Warriors, they actually listed what the documents were that they were releasing and what they were redacting. But they chose to do something different with the ballpark. Let me also point out that on January 27th, they uploaded the same index twice, so they can. I guess they say that they submitted 2 documents on that date, but it's actually they uploaded the same exact thing twice. Again, that's the game they're playing. They're flooding you guys with documents and arguments, and just trying to hide why they decided to relax the COVID requirements of the ballpark, which I might add led to lots of disease.
Okay, I
among
see.
the workers.
Okay, I'm gonna let member neighbors have the floor. She seemed to have a question.
Thanks. So I'm
Member neighbors, you're on mute.
Oh, it doesn't say I'm on mute.
Oh, I think she's saying she can hear you now.
Okay. I'm having some concerns at the moment. I'm remembering the last time that we were speaking with Ms. Hawks, and at that point, she cited that the ordinance, I believe it was something along the lines of if the search would take longer than half an hour, it didn't have to be conducted or something along those lines. And this time I'm hearing her saying that the ordinance doesn't require information about redactions. For me, this does not instill confidence in the situation with the records. And I would like it if we could do, I think Mr. Norton has a very specific email in mind. I'm wondering if Ms. Hawks would be willing to go back and do a search just on the subject line of that email and provide us with a full set of records just on that email so that we can see for ourselves. And I'm wondering if I understand, that you do not have to comply beyond that date. But if there are emails within that period that we haven't seen or that are redacted, so we don't know that they are emails in response to this, like a redacted PDF or a redacted whatever, if we could just get a clear picture of the correspondence that took place that Mr. Norton is responding to, I think I would just feel more comfortable. It just feels like there's a lot of gaps and holes to me in the response. And one thing I would suggest, Ms. Hawks in the future, we have a great form. I know the ordinance is tough to read, but we have a great form that's basically a checklist of how you can make sure that you're providing everything that you need to. It's a form for putting together your respondents packets and basically your respondents' arguments around this as well. I'm not sure where you're getting the advice about the ordinance, but it's pretty far off. So I'd like to suggest that you maybe use a different resource to understand how the ordinance works so that you can get a bit more clear on that. Thanks.
I'm happy to look into the topic of, providing reasons for redactions. I'm just saying, though, that the guidance that I was given is that we don't need to that's not part of the ordinance, but I will look into it and we will get back to you.
Where are you getting that guidance from, Ms. Hawks? Who's saying that that you're not required to give reasons for redactions?
I mean, I can't go into all the details of where we're getting all of our information, but that was the assessment from our office.
Okay. Well,
but I will look into it again and get some clarification on that.
Okay.
I'm curious if in other cases whether you're getting reasons for redactions listed.
Yes.
Yeah.
And if that's something you typically see.
So this is Chair LaHood again. Yes, this is something that's required when there are redactions, but also, to be clear, this is a point of confusion that does come up. So we are trying to educate departments so that people don't have to keep coming back on this, because it is something that I think is easier to do the first time around. While the redactions are being done, keying them at the time of the redaction is much easier than going back and doing it later, and it ensures that there's full compliance with the Sunshine Ordinance. I think that's what Member Neighbors is encouraging.
Chair, okay. Can I just say something quickly?
Ms. Leger, please go ahead.
Yeah, my understanding is they have to provide legal reasons, not just say, well, I felt like this needed to be redacted. They have to be legal citations, is my understanding.
That is correct. That is correct.
Yes.
There has to be a legal reason for the redaction.
Exactly. Yeah.
Okay. Well, I'm
members.
happy to look into it. I'm happy to look into that and understand that more clearly. So I appreciate the discussion around this.
Yeah. I think it's useful for everyone, because it sounds like Mr. Norton will be coming back with other requests, and Mr. Norton and others will come back with other requests, and we want to save everyone the time of being able to just get the information they need, and when we make orders of determination and we follow up with compliance, we hope that departments are learning so they don't end up back here for the same reason again. Members, how would we like to handle the situation? Actually, Member Wong, based on your close reading of this case and where we are with compliance, do you have a recommendation, or do you have additional questions or a proposal you'd like to make to the committee?
I don't have any additional questions. I am reluctant to move this along to another meeting, given how long it has been, and now how many times we've requested, a clearer index of records and keyed redactions. The order of determination now is made 4 months ago, over 4 months ago now.
April.
Yeah. I'm curious if you all have thoughts on how we should proceed with this one, because there are very specific things we're asking for, which we could wait for in the next compliance meeting, while hopefully Mr. Norton's able to, create new requests for any records beyond April 2021.
Member Neighbors, what are your thoughts on this?
I think we were very clear in what needed to be provided, and those things still need to be provided.
I'm inclined to ask for this again, to ask for compliance within a short period of time, not the 2 months between now and our next meeting. I don't think it's useful for us to try to send this back to the full task force, because really this is just ongoing compliance. So perhaps if Member Wong, if you want to articulate with precision, what we're looking for, and when we want to receive it by. And Ms. Hawks, if the department can deliver these things, then our next meeting will just be a verification that they've been delivered and that that the order has been fully complied with. So Member Wong, what would you propose at this point?
Sure. Yeah, I'll make a motion to request for a clear index of records for any records that were provided to Mr. Norton at or before his original request. So yeah, I feel like that is enough for that. And then also any redactions for those records be keyed. And I would like to see that within 10 business days.
And to add some clarity to that, if the index of records includes a document whose title, of which the title has been redacted, we need an explanation for why the title has been redacted. For example, if it's something that was that is related to attorney-client privilege, we would need to have that specific reason associated with that redacted title. Is that what you're asking for?
Yes, in addition to a key for every redaction that was made on all of those records as well.
Ms.
Sorry,
Leger,
could I ask?
Yes.
Could I ask a question?
Sure.
I just wanted further clarification on what a clean index of records means. It sounds like there was the index that we previously provided was not satisfactory. So what do we mean by that term?
Sorry, so I said clear, and by clear I mean an explanation of what documents are being provided. And then again, as Chair LaHood mentioned, if the title of the document has been redacted, then we also need a key for those redactions as well within the index of records.
So for example, if the index says a PDF with a redacted title, meaning we can't see what the title is, we need an explanation for why the title has been redacted. For example, it is covered by attorney-client privilege. And that is just an example because it's something that comes up. I'm not suggesting that this be put on something where it's not an appropriate match, but that's just an example. Ms. Leger, do you have a clear understanding of Member Wong's
Motion.
motion?
Moves to request a clear index of records for records that were provided to Mr. Norton at or before his original request. Also, any redactions for those records be keyed. I would like to see this within 10 business days. If the index includes a record of which the title has been redacted, need an explanation of why it is redacted.
That sounds great.
Do we have a second for?
Yeah.
I'm sorry.
Second.
Do we have a second?
This is Member Neighbors. I'll second.
Okay. We have a motion. We have a first. We have a second. I'd like to open this up for public comment. Mr. Young, do we have anyone in the queue? And if anyone who's not party to the case would like to make public comment, you can join the queue if you're on the phone. Press *3 to enter the speaker line. If you're on WebEx, you may use the function to raise your hand. Mr. Young, do we have anyone in the queue who'd like to make comment on this motion?
We have one in line at this time. I'll unmute them.
Okay. Speaker, if you could wait until Ms. Leger says she's ready with the timer, and then you may speak.
Speaker, what do you have a name?
Sullivan.
Okay. You ready, Mr. Sullivan?
Yes.
Go ahead, sir.
Just to help the respondent, Section 67.26, withholding kept to a minimum. That's where you'll find the key. Says information that is exempt from disclosure shall be masked, deleted, or otherwise segregated in order that the non-exempt portion of a requested record may be released, and keyed by footnote or other clear reference to the appropriate justification for withholding required by Section 67.27 of this article. This work shall be done personally by an attorney or other staff member conducting the exemption. And it goes on. On the indexing, Section 67.21c, a custodian of public records shall assist a requester in identifying the existence, form, and nature of any record or information maintained by, available to, or in the custody of the custodian, whether or not the contents of those records are exempt from disclosure, and shall, when requested to do so, provide in writing within 7 days following the receipt of the request a statement to the existence, quantity, form, and nature of the records related to a particular subject or question, with enough specificity to enable the requester to identify records in order to make the request under B. That does not mean redacting your index. All right, thank you for your time.
Okay, just doing another check on the list of public commenters. If you do want to make public comment this time, you can raise your hand, *3, or otherwise using the application to raise your hand. I do not see any additional parties with their hand raised at this time.
Okay, that was last call for public comment. Public comment is closed. Ms. Leger, please call the vote.
Hang on just a second. Member Wong.
Aye.
Member Wong, aye. Member Neighbors.
Aye.
Member Neighbors, aye. Chair LaHood.
Aye.
Chair LaHood, aye. Do I need to read the motion again?
Yes, please.
Moved by Member Wong, seconded by Member Neighbors. Moved to request for a clear index of records for records that were provided to Mr. Norton at or before his original request. Also, any redactions for those records be keyed. I would like to see this completed within 10 business days. And if the record includes a record of which the title has been redacted, an explanation of why it is redacted is required.
I want to make sure that it's clear that this is a request of the Department of Public Health.
Okay, Mr. Request for clear.
I mean, it's sort of obvious given that that's what this case is, but I want to make sure that that is clearly stated.
All right, moves to, Member Wong moves to request for a clear index of records that were provided to Mr. Norton by the Department of Public Health at or before his original request. Shall I say it again?
No, that's fine. I just wanted to make sure that the name of the department was included.
Yes.
Member Wong?
And then I should also specify 10 business days means on or before September 7th. So, or actually September 8th maybe because Labor Day.
It might be the 8th because of Labor Day.
So let's say September 8th, on or before September 8th.
Okay, got it.
Okay. I want to thank Mr. Norton and Ms. Hawks for being here today. You may go now. We hope to see those documents within 10 days, and then we will circle back to make sure that we've had full compliance on this order of determination. Thank you all. Ms. Leger, if you could please call the next item.
Just a moment. Item number 5, file number 19124, complaint filed by Anonymous against Chief William Scott, Lieutenant R. Andrew Cox, and the Police Department for allegedly violating Administrative Code sections 6721, 6725, 6726, 6727, by failing to assist in a timely or complete manner, by failing to provide a timely or complete response to a records request, by failing to provide rolling responses, by failing to withhold a minimal portion of public records, by failing to provide written justification for withholding. On June 22, 2021, the Compliance and Amendments Committee continued the matter to the call of the chair. The committee requested links to the portal documents specific URL. Once referenced, redacted documents are uploaded and available online.
Okay, first of all, we want to make sure that we have the petitioner and the respondent, someone representing the police department here. Mr. Young, can you tell us if we have both parties present?
Yes, if you are a party to this matter, you can raise your hand at this time by pressing *3 or otherwise raising your hand. I had one person with a hand raised. I do not see any others yet.
Good afternoon. This is Lieutenant Lynn Riley, San Francisco Police Department.
Lieutenant Riley, thank you for being here today. Can we have we identified Anonymous yet as being on the line?
I do not have any other hands raised at this time.
Okay. Ms. Leger, did you hear anything from Anonymous about being able to attend or not attend today?
No, I haven't gotten any emails or phone calls. I mean, I haven't seen anything.
Okay. Did you, was there any affirmative acknowledgement of this being on the agenda?
Let me just take a look in the file. 124. I have the notice that was sent out for today's agenda, and the police department's submission of records. That was Friday, June 18, 2021. I haven't heard anything from Anonymous.
Okay. Member Wong, you took a close look at this case. If we don't have the petitioner here, do you still feel comfortable proceeding with a review of compliance on this matter to at least move things forward a bit?
Yeah, I think that would work. Okay.
I'm going to recommend that we give Lieutenant Riley a few minutes to explain what the department has done in order to comply with our order of determination, and then Member Wong, I will turn primary questioning over to you. Lieutenant Riley, if you'd like to explain what the department has been doing to comply with our order, that would be appreciated. Thank you.
Thank you, Chair LaHood, Member Wong, and Member Neighbors. Yes, I absolutely would. So there's a letter dated June 18th, 2021, and I believe you all have that. And if you don't, I can read it, but I'd like to spare you that and just address a few of the things that occurred that caused this delay. And we did take responsibility in 2019, late 2019, for the delay and not providing the response to the requester within the required time frame. Essentially, the requester had submitted a request through an active email entity at that time, which was not being monitored operationally. And so I'd like to just address that for a moment. Due to the voluminous requests that we now can have increased quite a bit, we shut down that email entity because things were being missed on that email, not just this type of thing. And it's only used now for internal purposes. So that's not really an access for anyone's request. At this point, everything goes through the public portal for requests. It's much more efficient. We can use our software platform to track requests and keep everything organized. So I shut that email down myself, and I've worked for legal since I think, late February. So that email has been completely shut down at this time that caused that original problem, because operationally it was causing others, as I stated. So now we have a clear path. We are also in the practice of, I would say, like, back to the specific complaint, there was a misunderstanding regarding what the requester was asking for originally, and it appeared that it was originally submitted as like an immediate disclosure, and FFPD had interpreted it as this vast thing that was going to be taking way too long, et cetera, and immediately extended it. When it was determined that that was not the scope of the request, then SFPD readdressed the request and started producing what was available. I would like to add also, though, at that time, that I don't think, according to the documents that I have, we were putting the redaction codes in a key in the appropriate places for every redaction. So we were not delineating what the government code was, why we were applying reductions at that time. We then had to go back and correct that as well from the committee. Let me just look at my note one more time and make sure if there's anything else I could add. Now, the detail of exemptions I already covered, and then we submitted revised information. Also at this time, related to Senate Bill 1421 productions, those things that are now produced are online and accessible to the public. And those are organized by date. So I think there's been a lot of developments prior to me getting here, and then some other things we're trying to do operationally to make this a little more seamless. But we definitely dropped the ball on this with those mistakes.
Thank you for your update. Member Wong, do you have questions?
Sure, yeah, I have a couple of questions. So I will state we do have the letter that was from June 18th, 2021. And I think our last compliance amendments hearing or committee hearing on this particular file was actually after, on June 22nd, 2021. And I think part of the issue of this letter is that the link that is provided goes directly to the homepage of the portal. It doesn't actually link to the files that are responsive to Anonymous's request. I didn't see any other links provided in the packet, and I'm curious if any follow-up beyond June 18th, 2021 was sent, either to Anonymous or to this task force.
You know, I'm going to have to go back and ask members in legal division if, you know, that link is not, if that link is going directly to the website and not to the actual documents, then I have to revisit this with staff and find out what the situation is. And I do not know if, my understanding was that we were continued to release things to the requested materials to Anonymous. At this time, we were in the clear as far as we were finished with this assignment. But I didn't know the link was supposed to be those documents, so that's an error.
Okay, and then I do have one more question. So I know you mentioned already that redactions were being keyed after the last hearing. I'm not seeing those in the packet, though. I don't know if that information was provided to us outside of the portal, especially because we don't know which files specifically are responsive, so we unfortunately can't check if they've been keyed via the portal.
So, Member Wong, if I'm understanding correctly, your two questions are, is there a link to the requester's materials specifically? I don't know if there is, but, and then the second one is, I'm sorry, I lost you on the second question.
No, no problem. So you had mentioned that you all had gone back and keyed redactions in the records that were responsive that you provided to Anonymous, but I don't have any evidence of that, unfortunately, because we don't have a direct link to those records in the portal, and then I don't see it in this committee's packet. So I'm curious if it was provided to us that you know of, because I don't have any record of it.
Okay, that's a very good question. I do not know. I don't have an answer for that. So I'm going to have to check on those two things. And it might be easier if we cannot provide a link directly to those respondent records that you're requesting for this particular request from Anonymous, then we would have to provide those. I don't think we have direct links to any of the requesters' materials directly, because that's a separate database for production. So I'm going to have to follow up on both of these issues and also find out if we have the redacted record or the records with the redaction codes on them.
Okay. And then can I make a recommendation? I think in the public records portal, there are request numbers. So I'm curious if you could get the request number for this particular file. I think that would help us a lot because, you know, we do have access to the portal. We just don't know what request number it is or what packet, you know, of information. So,
okay, I think that's a great point, and that could also be included in the letter. So for future reference, it would be right in front of everyone.
Yeah, that would be great.
Thank you very much for that.
Chair Hood, were you going to say something?
I was going to ask, because I know this goes a ways back, and Lieutenant Riley, it sounds like this was a case that you have inherited. Is that correct?
Yes.
Okay. I just wanted to ask Ms. Leger, and as far as you know, did we receive anything related to this file that was not included in the packet? Or as far as you know, everything is as far as you know, is everything we received related to this file in the packet?
Yeah.
Okay. Okay. Members, any other questions? Member neighbors, I want to give you a chance here as well. No. Member Wong, how would you propose that we proceed? I know I'm glad that we got this update. It's unfortunate that Anonymous was not here, but perhaps Anonymous is not here because I don't know. We don't know why. But how would you propose that we proceed with this?
Yeah, I guess I would request for Lieutenant Riley and or SFPD to provide a link or a request number for records associated with this file for us to be able to check the public records portal. I think, yeah, unfortunately with Anonymous not being present, we can't confirm or deny whether he's been receiving those records or not. So I think it would be great if we could at least check that, you know, redactions are being keyed correctly. And I think those were the main things that we actually requested in our order of determination.
So seeing as that these issues are still outstanding, would we like to put a time request that this be complied with? Would you like to say 10 business days as before? Because it seems as though if there's been compliance and these documents exist with the appropriate redactions, it should be fairly simple to provide us either a link to those files or the, as you said, the request number so that we could go into the system and verify ourselves.
Yeah, 10 business days sound great. Again, on or before September 8th of this year.
Okay. Do we have a second for this motion?
This is Member Neighbors. I'll second.
Okay. Ms. Leger, do you have a clear description of what we're asking for in this motion?
Moved by Member Wong, seconded by Member Neighbors, to request the San Francisco Police Department and Lieutenant Riley to provide a link or request number of records associated with this file to check the public records portal that redactions are being keyed correctly, and request that compliance to this motion be within 10 business days on or before September 8th. Did I get that, Member Wong?
That sounded correct to me.
Okay. Do we want to open it up for public comment?
Yes, please. If anyone would like to make public comment on this motion, if you're on the phone, you can press *3 to enter the speaker line. If you're on WebEx, you can raise your hand. Mr. Young, do we have anyone who would like to make public comment on this motion?
I do not see any people, any additional parties with their hands raised at this time.
Okay, just because we just started talking about this, I want to make sure that there's not anyone who might be trying to make public comment. If you'd like to make public comment on this motion, press *3 to enter the speaker line or raise your hand on WebEx. Is there anyone who would like to make public comment on this motion?
Still no indications.
Mr. Young, do we have anyone?
No additional.
Okay. Ms. Leger, please call the vote.
Member Wong.
Aye.
Member Wong, aye. Member Neighbors.
Aye.
Member Neighbors, aye. Chair LaHood.
Aye.
Chair LaHood, aye. Okay.
Okay.
On to item number 6.
Yes, Lieutenant Riley, thank you for being here. We appreciate your participation. Ms. Leger, please call the next item.
Item number 6, file number 22057, complaint filed by Stillian Byzanski against Sean Borisson and the Planning Department for allegedly violating California Public Records Act, Section 6254, C as in cat and K as in kite, regarding failure to redact personal contact information.
Okay, I want to make sure that we have all parties here. I know Mr. Byzanski was here earlier. Mr. Byzanski, are you still on the line? If you could please unmute yourself.
Yes, I'm still here.
Okay, great. And do we have someone from the Planning Department?
Yes, Laura Lynch is present.
Okay. Okay, so this is a hearing to determine jurisdiction to see that if we have the facts and matters of the case, if the Sunshine Ordinance Task Force is the appropriate venue for this, and if we have jurisdiction. I would like to, because this is the first time that we're hearing this and we're determining this, I am going to ask for a timer on this. So, Ms. Leger, if you could give Mr. Byzanski 5 minutes to discuss his complaint, and then we will give Ms. Lynch a chance to respond.
Mr. Byzanski, are you ready to begin?
Yes, I'm ready.
Go ahead, sir.
Sure. So it's quite simple, a complaint. As per my public request from April 13, 2022, I should have received a public request with my personal contact information redacted. It appears some of the contact information was redacted, but there was plenty of information that wasn't. And I think I have attached some proof as part of my complaint. But there's plenty of more. I'm not sure how much evidence you want. And I think that should be considered a violation of 6254C and section 6254K of California Public Records Act, Article 1, Section 1 of the California Constitution. That's pretty much it. Thank you.
Okay, that was fast. I'd like to give Ms. Lynch a chance to respond. Although Mr. Bazanski did not use 5 minutes, I extended 5 minutes to him, so I will give Ms. Lynch up to 5 minutes to respond.
Ms. Lynch,
Thank
your first name, please.
Laura?
Laura. Are you ready, ma'am?
Yes.
Go ahead.
Okay. So this should be brief as well. I just wanted to give an overview of the request for records. So as Mr. Bajanski stated, on April 13th, he requested for the planning department to produce all records with the name Cillian Bajanski and or email address, and I won't say that right on the record now, along with a specific address. And in doing so, we provided all emails with both his name, email address, or the specific address requested. And the only items that were redacted from those emails or information redacted were called out in the email provided to Mr. Bajanski on May 2nd, along with each individual redaction keyed for attorney-client privilege. That is the only thing that was redacted. We did not redact any contact information. The only contact information I see on here are the email address, which was requested by the requester, and we provided the records within a timely manner as outlined within the Public Records Act and the Sunshine Ordinance. And that concludes my presentation. Thank you.
Sorry, I was on mute. I have a question for Ms. Lynch. In the request you received, so the request was made for all records with regarding the name, email address, and or the specific address. Were you asked to return it with those items, with that information redacted?
No, we were not requested of that, and we received this same request from Mr. Bajanski pretty regularly with specified dates. So we were just providing the information as previously requested as well. But again, the request did not request any redaction.
So you responded in the same manner that you had responded to previous requests?
Correct.
Okay, I want to ask Mr. Bajanski, when you made this request, as far as from your perspective, did you ask, you made this request, did you ask that that information be redacted when it was returned to you?
I did not, but what I have seen from other departments, they do that. So I assume all the departments should do it. And I think it's a good idea to do it because it involves personal contact information.
And the documents that you received back, were these, can you tell us a little bit for everyone who's here, tell us the nature of the documents that were returned back?
Well, it's email correspondence, and it has my email address visible. It also has my phone number visible. And the concern I have is that there's an ongoing litigation, and that might affect that litigation because obviously somebody could Google and those things that are not redacted are actually indexed. It's a public request, so it's available to the public.
Okay, and you used your either your primary email address or a work did you use an email address that is a typical email address that you use for other things, or was this one that you created specifically to communicate with the city?
No, I haven't created an email specifically. It's my primary email that I use on a daily basis.
Okay. Okay, members, do you have other questions about this? Okay, I'm going to initiate a discussion with the other members here. It seems as though since Mr. Bazansky was communicating with the department using his email address, actually, I'm wondering about this. He was communicating with the department and requesting documents that returned his own personal information, but then the responses to the records requests become public. To what degree should there have been redaction of any of that information?
This is Member Wong. It's still personal information.
Mm-hmm.
And, you know, I think if you redact it and you added the correct key for it, I think it would potentially be obvious why it was redacted.
May I just, sorry, this is Laura Lynch. You can tell me to wait. I just wanted to add one piece of information about how the records were produced, if that would be helpful. They were emailed directly to the requester as a zip file attachment. They were not posted online. We don't use Next Request, so they weren't visibly made available to the public. We only provided the records back to the requester. We don't use Next Request at this time.
Ms. Lynch, if someone else requested the responses to all record requests made by Mr. Bazansky, so if someone else had requested this, would you have actually, you know what, I'm getting way off topic on this. So this was not posted publicly. So it was a request for public records returned. Actually, members, let me ask this question. Do we have jurisdiction in this case? I believe we have jurisdiction in this case. I will answer my, am I frozen?
No, I agree. This is wrong.
Okay. I believe we have jurisdiction here. I'm wondering if some of my questioning may be getting too much into the case. Do you think that this is this a matter that should be considered by the full task force?
I believe so.
Okay, that was Member Neighbors. Member Wong, do you agree?
I do.
Okay. Would we send this to the full task force with any sort of recommendation?
In my mind, based on the questions that we've asked so far and based on the ordinance, the information should have been redacted. For the line of questioning you were about to go down but stopped yourself from, is that these are public records no matter how they distribute them, and so now they're public records, and so the redactions, they should have been redacted accordingly. So I think that we could find a what is that finding?
This is Speaker Young. May I suggest that we refer it without a recommendation and ask the city attorney to chime in on this? Because just on a personal basis, I get different answers from different agencies. Like the Ethics Commission says they will refuse to redact any personal information on the Form 700s. I personally, on our app and our complaint forms, I put a statement in there that this is a public record and we will not redact. And so it is a question that changes from situation to situation. So you may want to get advice from our city attorney on this matter.
The difference with the Form 700 is that anyone filling out a Form 700 is in some way or form a city employee or serves on a city commission, and so the standards that apply to them are different than the standards that apply to members of the public.
Yes, just to take it even further, correspondence received by the Board of Supervisors We will not redact any email addresses or any information provided in those emails to us. So once it's submitted to us, we will not redact the email addresses or anything to that effect. So I believe we should pose some type of question to our city attorney to help the full task force come to terms with this matter.
I will.
Can I just say something? I will say that I often get complainants who will protest that it's my responsibility to redact their personal information, including emails. And I always tell people, if you want to be anonymous, do not use your personal email as identification, because many people have their name in their email address. And that it's if they want to remain anonymous, the smart thing to do is create an email that is known to me and to the petitioner, and then nobody else will understand what it means.
Right. So at this time, I think the best course of action is that I'd like to make a motion to find jurisdiction. I know this is an issue that has come up before. I'd make a motion to find jurisdiction and send this up to the full task force for a hearing, with the request that we get some input from
We make advice from our city attorney.
Yes.
I would second that. This is Member Neighbors.
Okay. We have a motion and a second. I'd like to open this up for public comment. Are there any members of the public who are not party to this case who would like to make public comment? If you are on the phone, you can press *3 to enter the speaker queue. If you are on WebEx, you can raise your hand, and Mr. Young will let you know when it is your turn, and Ms. Leger will let you know when she's ready with the timer. Mr. Young, do we have anyone in the queue who would like to make public comment?
Yes, we currently have 2 people on the line. Actually, 1 person who would like to make public comment at this time. I'll go ahead and unmute them.
Hello, speaker. What is your name?
Sullivan.
Are you ready, Mr. Sullivan?
Yes.
Go ahead, sir.
So one of the records that I sent in just on that's supposedly for the item number 8 that never got in there. It's all about, one of the things it's all about is court cases and everything about redaction of emails and personal information. But basically it boils down to, if the public is voluntarily giving information to the government, then that becomes a public record. And if it's involuntary, it may or may not. And I can, like all the, for like benefit districts, when these people vote for the benefit districts, or they put a petition, their address, their phone number, their email address is all public. It's on the ballot. And that isn't even voluntary. You can voluntarily vote or not vote, but if you want to vote, you have to provide all that information, and it is public. Anyway, thank you for your time.
Thank you for your comment. Mr. Young, do we have anyone else in the queue?
There are no additional members of the public for public comment at this time.
Okay, members, any additional thoughts on this, or shall we? Okay, Ms. Leger, please call the vote.
Chair LaHood.
Aye.
Chair LaHood, aye. Member Neighbors.
Aye.
Member Neighbors, aye. Member Wong.
Aye.
Member Wong, aye. Moved by Chair LaHood, seconded by Member Neighbors, to find that there is jurisdiction and to send this matter to the task force for hearing, with the request that we first obtain advice from our deputy city attorney.
Okay, Mr. Brzezinski, Ms. Lynch, thank you for being here today. We appreciate your participation. Ms. Leger, please call the next item.
Okay.
Wait, before we call the next item, actually, I am going to say let's call, we were talking about taking a brief break, but we've been moving fairly quickly. Members, would you like to continue? I think we should continue. I feel like, Ms. Leger, are you okay if we continue, or do you need a break now?
I just need like 15 seconds to go close a window.
We will allow that.
Thank you.
I can fill the time. We're taking a brief break for a temperature adjustment. Thank you all for your patience.
For the next item, Chair LaHood, I prepared a little bit of background just to give us a nice timeline. If I could do that before we hear from, I think the folks, I think that would help us all stay clear and help them be able to talk about new stuff rather than old stuff.
That would be much appreciated. I'm happy to let you do that first. We're just waiting for Ms. Leger to come back from the window.
You know, these San Francisco windows can really stick.
I'm going to go ahead and read the item for to get us started.
Oh, you know what? That would be very helpful. Mr. Young, if you could read the item number 7, that would be great.
Yes, item number 7, file number 21149, complaint filed by Mark Sullivan against David Steinberg, Public Works, for allegedly violating Administrative Code section 67.25 and 67.34 by failing to respond to a media disclosure request in a timely and or complete manner, and willful failure to discharge duties imposed by the Sunshine Ordinance.
Okay, Mr. Young, thank you. Let's first find out, Mr. Sullivan, are you still here on the line? Can we make sure that Mr. Sullivan has been unmuted and is available to participate? Okay, great. We heard you, Mr. Sullivan. Mr. Steinberg, are you here with us today?
I am. I don't know if I've been unmuted, but
you have been unmuted.
There we
can
go.
Hear you. That's why I ask, and thank you for both for being here today. I am going to hand things off first to member Neighbors, who has looked at this case extensively and is going to give us a brief summary before we ask you both to give us an update on where we are. Member Neighbors, you have the floor.
Thank you. I wanted to, so I actually am looking at this case and actually the next item, because they were combined, the two files were combined. I actually wanted to go back and listen to the audios of all the places they had been to ensure that we're really clear, because there's been a lot, as everyone knows, they've been in front of a lot of our subcommittees, and there's been confusion before. And I think in the past we've taken up a lot of time with just trying to get the basic timeline straight, you know, and the basic facts. So I thought I would just start us with that, and then when we're hearing from Mr. Sullivan and Mr. Steinberg, we can really focus on new information to help us move forward. So the background is Mr. Sullivan opened his original request that we're dealing with to DPW in April of 2021. Some records were produced. They weren't the ones that Mr. Sullivan was looking for, but he began to work on determining some different search terms, so it have narrowed his request. And at that time, Mr. Steinberg consulted with the city attorney with regard to the balancing test, the mayor's 5th supplemental proclamation, and then Mr. Steinberg, of his own volition, closed the next request ticket. Mr. Sullivan then opened a complaint, and the complaint committee, this is for file 21069, heard the complaint in September of 2021. Then the matter was heard before the full task force in November of 2021. Full task force found that Mr. Steinberg was in violation of CPRA 6254B for withholding all records in their entirety and ordered him to resume producing records under AC 6726. The finding in file 21069 was referred to compliance and amendments for monitoring, right? So Mr. Steinberg then began producing records again. But then Mr. Sullivan filed a complaint for willful misconduct after the hearing of 21069 at the complaints committee, during which he learned that Mr. Steinberg was a managerial city employee. And that's what file 21149 is. Education, Outreach, and Training heard 21149 in January of 22 And at that point, at that point they decided to combine it with 21069. They referred the matter of the records production to compliance and amendments for monitoring, and referred the matter of willful violation to compliance and amendments to be heard without a recommendation. Okay, so that's the cases, the information in the cases are basically identical, but it's a matter of what was heard by Mr. Sullivan at the complaints committee that led to the willful violation. So we have two things today. One is to check in on the records production, and then the next is then within that same content matter to hear the complaint for willful violation. And then the note on that is that allegations of willful violations are normally addressed by the Ethics Commission. So that's the background. I hope it's helpful.
That was helpful. Thank you. Member neighbors, I am, as you have done extensive research on this, I'm going to let you lead the questioning. Well, actually, first, I'd like to give, if you think this is appropriate, give Mr. Sullivan a few minutes to give us an update, and then give Mr. Steinberg the same. As we did earlier, I'm not going to set a time limit, but I do ask that both parties be concise in giving us an update so that we can move then on to specific questions that will help us with our compliance review. So Mr. Sullivan, we'll give you a chance to go first. If you could just give us a concise update, that would be very helpful. Thank you.
Okay. Oh, you want me to start? This public record request should have never gotten this out of whack. To give you a little bit more, just a little bit more background, Mr. Steinberg does not allow a request for public information in the form of a question because he claims them to be interrogatories and not allowed. This is just not true in either the CPRA or especially the Sunshine Ordinance 6721C and 6722-2. So what should be a simple question or information like, is DVW working on any new green benefit districts, has to be turned into a record request around the subject. This is why this record request exists. To date, there have only been 4 records that are responsive out of 1,886 records produced to my request. Sunshine Ordinance Section 6725D and CPR 6253-1 records need to be responsive. So he's just flooded me with unresponsive records. And the four records we're inquiring into starting a green benefit district are variations of the same email communication. There may be other responsive records, as Mr. Steinberg is withholding records under Evidence Code 1040D2. Keep in mind, I believe Mr. Steinberg intentionally inflated the number of responsive records with the intent to obstruct real responsive records and to not respond to the record request. Given records given include commercial ads, JPEGs, logos, communications with DPW on various issues, none inquiring about starting the benefit district. With my request, it seems Mr. Steinberg has thrown everything he can think of to delay and obstruct. And CPRA 6253D, nothing in this chapter shall be construed to permit an agency to delay or obstruct the inspection and copy of a public record. I just want to say with this request, Mr. Steinberg willfully closed the public record on May 12, 2021, knowing that there was what he claimed about 2,000 responsive records. Mr. Steinberg at the time was a manager with 1 employee under him at least. A custodian of records cannot close a record request knowing there are records responsive to a request. It defeats the entire purpose of the public access laws. The initial claims was there was about 13,000 records, 7,500, 8,586. The numbers jumped around. In trying to narrow the request, I asked Mr. Steinberg for assistance and he correctly stated the mayor emergency proclamation of requiring that the proclamation did not extend to CPRA 6253.3, which requires assistance. Mr. Steinberg said that him giving me numbers every time I modified my request was giving me the required assistance. This is not what the law states. Since I was not getting any assistance, I attempted to learn what and how he was searching through another request. And he was releasing those search instruction records when he closed my public record request on inquiry into starting a new green benefit district. The ordinance, Sunshine Ordinance, requires records to be produced as soon as possible that they are received and collected. If Mr. Steinberg started producing records, I could have narrowed my request by looking at the records. He did not do this. It is clear in Mr. Steinberg's action that he had no intent on producing responsive records and willfully closed the public record request. When directed by the task force on November 2021 to reopen the request and start making public records public, he has continued to delay and obstruct making records public by any means possible. Thank you for your time.
Thank you for your comments. Mr. Steinberg, would you like to give us an update regarding these the item we're discussing?
Sure. I will limit my comments to the first, what is it, item 7, which is the first item, which is about willful misconduct. Yes. And I can go over some of the things that he said afterwards or in response to questions. So 21149, as neighbors said, is a complaint is over the same set of records that are at issue in the next item, which is file 21069. The only difference here is that Mr. Sullivan is also alleging willful misconduct. All I can say is I've dutifully carried out my duties as custodian. I initially closed out Mr. Sullivan's request using the balancing test, which was available due to the mayor's emergency proclamations and only after consulting with the city attorney's office. The task force ruled that closing out the request was improper and ordered me to turn over the records, which I have done. I'm not a lawyer, but given the fact that the city attorney and the task force have different opinions on applications of the balancing test, and the fact that I've followed the task force order to produce the records, I don't see how my actions could be considered willful misconduct. So I'll leave it at that, because that is as far as I can. In my reading, that's the only thing that is at issue with item 7 is the willful misconduct.
Okay, member neighbors, what questions do you have for our parties?
Thank you, Mr. Steinberg. Could you speak a little bit to the responsiveness of the records that you've produced since the task force found you in violation?
Sure. So, as you know, because it sounds like you've gone through these records a lot. Mr. Sullivan had requested information about any attempt, or he'd asked for any documents that showed basically requests to start green benefit districts. Now, in the easiest thing to do would be to go to the green benefit district manager and say, have there been any requests? Give me all the records. Unfortunately, the person who was the green benefit district manager is no longer, and at that point was no longer with the department. I talked to the people in the department who have essentially taken over those responsibilities, and they said they haven't done any work on them. They haven't engaged in any activities to promote them, all of which I told him I gave to Mr. Sullivan. And in fact, there were a few documents that were in the files that were responsive, and I did turn those over right away, even before the task force meeting. So then the question of how to find documents that show that someone has inquired about starting a GBD. I worked with IT to come up with a search query. It's not a perfect system. You know, it's difficult to frame a keyword search for inquiries about establishing a GBD as opposed to just anything that mentions a GBD. So, you know, I try things like GBD or Green Benefit District and either the word start or create or, you know, things like that. And that's where I got the, you know, 8,500 or 8,800 responsive records. And so after the task, and so that was why I initially had, and I think at one point, yeah, it was like 20,000. So after the task force order, Mr. Sullivan basically wrote back the next day and said, okay, here's my request. I want you to look for these. So I tried to work with Mr. Sullivan to come up with a reasonable search. Believe me, he's describing motives that are far from reality. I was not trying to delay giving him things. Believe me, it was not the highlight of my week to spend, you know, a certain amount of time for however many months I did every week going over these records. That's not how I like to spend my time, but you know, that's how it worked. I had our IT team run 4 separate searches. I relayed the results to Mr. Sullivan each time, and I tried to suggest on how we could improve the search to get him the records that he was interested in. So like at one point I went through some, and again, I suggest, you know, keywords. So when he says that I released 1,800 records, but only 4 were responsive, the fact is they were responsive to the IT search that we did. You know, if you have the word create and there's a phrase that says GBD. Well, one of the things is the person who used to be the Green Benefit District Manager had in his signature line Green Benefit District Manager, and in one of the searches we excluded anything from him, but in the ones that he submitted after the task force, he didn't do that, and so anything that Jonathan Goldberg wrote had the phrase Green Benefit District. So it was a matter of, did an email also have the word create or start, or I can't remember, I can look and find out exactly what the keywords were. And if a promotional flyer has that word in it and it was an attachment in one of his emails, that's going to be a hit. So I'm, you know, I know clearly the documents, other than, and I only saw 2 myself, but he apparently had found 4 that were what he was really looking for. If they weren't what he wanted, unfortunately, they were what he asked for, and you know, and that's why I tried to spend a lot of time trying to come up with and working with him to come up with a good keyword search, because if you make it too expansive, you're going to get the 8,000 records, which I don't want to spend all that time, and he doesn't want to look through them anyway, because they're not going to be what he wants. And if you're too restrictive, you're liable to miss documents that actually are what the person wants. So, I mean, I did as best I could. I informed him every step of the way what my search terms were, what I was doing, and you know, following the task force hearing, after we did the 4 email searches with IT, the meeting was November 4th. I started releasing records on November 30th. We devoted time every week to Mr. Sullivan's request. I released more than 1,000 emails on a rolling basis until we concluded production and closed requests on June 28th. So that's the whole history of what we did. Yeah.
Thanks, Mr. Steinberg. Mr. Sullivan, so it sounds like after the ruling, Mr. Steinberg is saying that you worked together to think about what keywords should be used to search to ensure that you got responsive records.
Okay.
Was that your experience or your memory of that as well?
No, so he's talking about like afterwards, and this is before he closed down the public record request, when he willfully closed it down. First of all, if he never in the communications before that closure, he never told me that the Department of Public Works was not working on any green benefit district projects or anything. There was no communication whatsoever like that. It would have been over. I would have just said, fine. The second thing is that the only thing that he helped me before he willfully closed down that thing was he gave me the number. Every time I would come up with different search terms and stuff, he gave me a number. Okay, you're at, 20,000. That's when we started, and then went all over the place, And I was trying to figure, since he wouldn't help me because he claimed the mayor's proclamation didn't require him to help me. It's right in the records that him giving me a number was essentially him helping me. Every time I tried to find out how he searched. So I opened up another public record request asking for the manuals and everything, instructions that they give employees on how to do request searches so that I could do that. When he was releasing those documents, that's when he closed down the record request. And it's like you guys determined, once he says they're responsive records, you can't just close down a record request. If there's 20,000, I mean, I've heard that there's been huge numbers of records. And if there are all these records, then you got to just do it on a rolling basis. But those records ended up not being responsive at all. I mean, and there's no reason for him. And so if he's not putting in, my request was people inquiring to establish a green benefit district. And if you can't put all those things together as a search thing, I mean, he only looks at one thing like starting or whatever, he's going to get these inflated numbers.
Okay.
Can I make one comment, if I could, to one of your questions? Mr. Sullivan said I never told him that there were no records, that there was no activity in establishing GBDs. That was his initial request. Item 3 of his request, which you can see it's on next request, is any records as to activity by Public Works in establishing green benefit district from March 1st, 2020 to April 29th, 2021, other than Mission, Dolores, and green benefit districts. And on that same day, I wrote him a note saying we've concluded a diligent search for records responsive to your request. We have found none for item 3. Accordingly, we have no records to produce in response to your request. So that I told him on November 12th, 2021, that there are no records showing activity in establishing a GBD. That's just for the record.
Okay.
Okay, and just to be clear, and then we can hand it back over for more questions or discussion, but at the time of the original request, Mr. Steinberg, the reason that Mr. Sullivan went back and made the willful violation or opened that file, made that complaint, is because he learned at the complaints committee that you were a manager, a managerial city employee, and that's kind of a threshold for willful failure, among others. So I just wanted to check, were you at that time a managerial city employee?
At that time, yes, at that time I was, I believe, 2020. Yes, I was. Although unfortunately, I lost the only employee who I supervised, so I no longer have any help working on records requests substantially. But I'm still considered a manager. That's my classification, manager 1.
Okay, thank you, Mr. Steinberg.
Member neighbors, do you have any other questions or Any other questions on this matter?
Not at this time.
Member Wong, do you have any questions on this matter? Member Neighbors, how do you propose that we should proceed for considering the first of the two joined items?
The first being the willful misconduct. In my mind, this is a tough one for us. And that's the reason we very rarely use this unless we have evidence for a willful violation. I'm curious if you, especially when you have more tenure with the task force, Chair LaHood, if you feel that we have enough evidence or information to support a violation of willful misconduct or willful violation for this.
It seems difficult for me to find willful violation when the respondent shows up and continues to engage and participate and provide responsive documents, even if it's not exactly everything that is requested or exactly everything the way we would want it in an ideal situation. And I do understand Mr. Sullivan's frustrations at not. I understand Mr. Sullivan's frustrations, but I think it's hard to justify willful misconduct when we have a representative who has been responsive to some degree. I don't know, members, what are your thoughts on this?
I mean, for me, this is Member Neighbors. Over time, Mr. Steinberg has definitely shown up every time. At every step of the way. There are times he's been inconsistent with what he said, for sure. We've questioned that and we've documented that and looped back around to it a few times, especially around Mr. Goldberg and his role. I remember that from very early on when we were hearing this case. But I don't believe that there's enough evidence to find a violation, willful violation.
Okay, so at this point, Member Wong, any thoughts or questions, or how should we proceed with this? Actually, I'm looking at the specific wording on the agenda. We still have 21069 to consider, which gets into, even though they're related, it's different details that we need to dig into. It seems that I guess the question is, does anyone want to make a motion on 21149? Is there a motion to be made?
I move we close the file with no finding for willful violation. Or is that appropriate?
I'm going to ask Mr. Young, do we need a motion in order to do that?
Give me one moment. That the task force made a finding of willful violation. Sorry, I'm not completely sure what the task force. I'll give.
They found a they did not hear the willful violation file. They referred it to us to hear.
There's no need to address the willful violation portion of this, as the full task force didn't make that finding. You can just make a determination of whether or not the order of determination has been complied with, and whether or not to close the file or conclude the file.
So these files are combined, but that doesn't mean they're combined under one file number. Is that correct?
Correct.
So we can close 21-149 and continue on with 21-069.
Correct. Is that that? I believe that is correct. And if I don't hear someone saying that's not correct,
that's how we'll proceed.
Okay, so we could, since we're not taking any action on this, we can just proceed, although I'm willing to open this up for public comment, even though that's not required, just because that's typically our practice. So, and just a final call, Member Wong, did you have any motion to make on 21-149, or shall I call for public comment?
Member Wong, you might be muted.
I believe she's getting a drink of water.
Chair LaHood, do you want to open it up to public comment?
Yes. So I was saying, Member Wong, at this point, neither Member Neighbors nor I had a motion to make on this. Do you have a motion to make, or should I just open this up for public comment before we move on? Okay. I'm seeing no motion from Member Wong. We will allow public comment on this item from members of the public who are not party to this case. If you are on the phone and you'd like to participate, like to make public comment, you can press *3 to join the speaker line. If you're on WebEx, raise your hand, and Mr. Young will let you know when it is your turn to speak.
We have one person who has their hand raised. I will unmute them at this time.
Thank you.
Hello?
Hello.
May I have your name, please?
Winship Hillier.
Mr. Hillier, are you ready to begin speaking?
I'm ready.
Go ahead, sir.
Thank you. Three things. I do disagree with Mr. Sullivan when he says that the law says that he can ask questions of the agency. There is actually case law on the books, and I will refer him to O'Reilly's Federal Information Disclosure, and that is applicable to the Public Records Act through precedent in California, to the effect that requests do need to be stated as requests for records. So a request for information is not covered by open records law. That's why it's called open records law. It's really an academic concern because most requests can easily be restated as requests for documents, i.e. instead of asking a question, is X true, you simply request the documents that are relevant to X. That brings me to the next point, which is that Mr. Sullivan is entitled to assistance in formulating a focused and effective request. And what those two words mean is focused means not requesting all sorts of irrelevant documents. So it's specifically the problem, it addresses specifically the problem that he's having is getting too many responsive documents. And effective means getting some documents, not getting a zero response, a zero records response. With respect to procedure, I think you should put a motion up to refer the matter to the full task force for a finding of willful non-compliance is the correct term. And I think you should put that motion up, even though no one supports it, because each item is a motion on the agenda, and that's what the request was for. And then you should all vote it down because none of you support it. So that's my suggestion. Back to you, Madam Chair.
Thank you for your comment. Mr. Young, is there anyone else in the queue who would like to make public comment?
No additional public commenters for this matter.
Okay, thank you. We are ready to move on to the next item. That said, it is 6:45 almost, and I would like to request that we take a brief 10-minute break. Would this be a good time to take that break? And then we will continue on with the rest of the agenda?
I'm fine.
Okay, let's come back at 6:55, and we will proceed with the agenda in order at that point. Thank you. So it is 6:55. We'll just wait for everyone to return to the meeting. And Ms. Leger, since we did take a 10-minute break, if you could please call roll again so we have verification of our members being present for the rest of the meeting. Ms. Leger, your microphone is muted.
Member Neighbors?
Present.
Member Neighbors present. Member Wong?
Present.
Member Wong present. Chair LaHood?
Present.
All present. Okay.
So thanks everyone for coming back after the break. Ms. Leger, if you could please call the next item.
Item number 8, file number 21069, hearing on the status of the order of determination, complaint filed by Mark Sullivan against David Steinberg and Public Works for allegedly violating Administrative Code Section 6721, B as in boy, C as in cat, by failing to respond to a records request in a timely and or complete manner, and by failing to assist the requester. 6725A, by failing to respond to an immediate disclosure request in a timely and or complete manner. California Public Records Act, Section 6253C as in cat, by failing to notify the requester of the possession of records of the agency, and by failing to notify the person making the request of the determination and the reasons for withholding. California Public Records Act Public Records Act, Section 6253.1A1, by failing to identify records and information that are responsive to the request or to the purpose of the request. On November 3rd, 2021, the Sunshine Ordinance Task Force found that Public Works violated California Public Records Act, Section 6253B, by withholding all records in their entirety and orders the respondent to resume production of records to the petitioner under Administrative Code Sunshine Ordinance Section 6726 for withholding all records in their entirety. In addition, the matter is forwarded to the Compliance and Amendments Committee for monitoring.
Thank you. Again, this was a case where member Neighbors took the lead on this one. Member Neighbors, would you like to, you gave us a summary, I think, for the preceding item and this one. Is there anything else you would like to say, or should we have Mr. Sullivan and Mr. Steinberg give a few comments on this? How would you like to proceed?
I think we're ready to hear from them.
Okay. Again, since this is about compliance and we're following up, I'm not going to ask Ms. Leger to set the timer, but Mr. Sullivan, if you could give us a brief summary of where you think we are at this point, and I'd like to give Mr. Steinberg a chance to respond after that, and then we will proceed with questions. So, Mr. Sullivan, please let us know if you're there, and we'll let you know if we can hear you.
Sullivan.
Okay, we can hear you. And Mr. Steinberg, are you back with us, and can we hear you? Mr. Steinberg, are you still there?
I am, but you'll have to answer the second question if you can hear me.
Yes, now we hear you.
Okay.
Okay. So, Mr. Sullivan, we'll let you speak first. Again, we're not going to set the timer, but please be concise in your remarks. Thank you.
Okay. First of all, I want to say that Mr. Steinberg is not telling the truth on the last thing. He said that item 2, he got back to me and said that there was no activities. If you look at the May 3rd, 2021, it says item 2 of the request sufficiently identifies records subject to disclosure, and we will continue to identify, review, and redact and release these to you. Part of your request seeking, and then he goes on to about item number 1. On May 12th, when he does close down the thing, he releases 3 records of activity that he claims are activity of the Goldberg. It's only after the Sunshine Ordinance Task Force ordered him that he said there was no records for item 2 and just focused on item 1. Okay, so, and this is right in the records. So he's released 1,886 records and produced only 4 responsive records, which were produced just over a year from the initial request. Mr. Steinberg has used about every tactic he can use to try and delay and obstruct the making of records public, violating public record laws. Besides failing to assist in closing a record, by failing to assist and closing a record request that had responsive records to, he has claimed evidence code 1040B2 and rule of reason and the need to redact incoming email addresses, inflating the number of responsive records to claim the request was too voluminous. I'm asking the task force to open up 3 separate complaints for these violations under the task force procedure 10. Issues of violations must be within 90 days of submission of the initial complaint to be combined within a complaint. These violations happen after the Sunshine Ordinance made their order, and these violations happened way months after 90 days of initial complaint. This boils down to what the task force allows to be permissive in response to a public record request. Mr. Steinberg claims to be withholding responsive records under evidence code 1040B2. A public entity has a privilege to refuse to disclose official information and prevent the disclosure of official information. If the privilege is claimed by a person authorized by the public entity, Mr. Steinberg claims he is the authorized. Regardless, Sunshine Ordinance Section 6724 on B, the following records are public records subject to disclosure under this ordinance too. A record previously received or created by a department in the ordinary course of business that was not an attorney-client privilege when it was previously received or created. I'm asking for records that were received. If any custodian record can prevent the disclosure of whatever records they want by being an authorized person, then it makes the public record law moot. There has to be a text. Mr. Steinberg incorrectly invokes the rule of reason of delay response to the request. Rule of reason does not apply to digital records or copy. Rule of reason applies to physical inspection of records at a location and directly from Bruce versus George, 1967, to be construed in favor of the broadest exercise by the public of the right of inspection. Rule of reason requires a custodian of record to formulate regulations. The city and Mr. Steinberg have no formulated rules of reason regulation. Mr. Steinberg took a little over 3 weeks to start producing records from the SOT when SOTF ordered him to immediately start on November 3rd, 2021. 1,882 records are not responsive, including 234 commercial ads. And I sent him this. This is part of the email that I sent him that's not in the pack. But even if he claims to look, you need to look at every email. So, I mean, every record, you just don't release commercial ads just because, you know, they're definitely not responsive to what I need. Mr. Steinberg claims he needs to redact email addresses of voluntary correspondence to DPW. He's the only custodian of records that does this that I know of. I have an example in the packet of the same email to DPW and one to the BOS, which did not redact the email address. In this request, I'm not really interested in email addresses, but Mr. Steinberg uses the need to redact to say he can only produce so many records a week. That's delaying record production. He should be told not to redact email addresses of people contacting and using it as an excuse to delay. If you shrug off the aftermath to give credence to the violations, and they will continue. I know it is hard work. Thank you for your time.
Thank you for your comments, Mr. Sullivan. Mr. Steinberg, we'll give you a few minutes to respond. Again, we're not going to use the timer, but I just ask you to be concise in your remarks. Thank you.
Sure. Well, I'll respond first to where Mr. Sullivan called me a liar. He's mixing things up. I said you can go back to the audio once you get it done. I said that there were no activities, and that was item 3, not item 2 of his original request. I read it to you exactly as it came in, and I read to you what my response was. Okay, so again, I'll address one other thing. Evidence, he goes down this rabbit hole of evidence code 1040B2. Evidence code 1040B2, which I've cited, and I have actually, at the suggestion of a city attorney, I've modified my template so it doesn't say I've withheld. I've only redacted. And if he looks at the documents that I released to him, it not only is a key at the bottom of each document, but it has a little black box with a word over it that says passwords. Anytime I've redacted for 1040B2, it's because I have redacted a password that is either to a program or a phone call or something else. That's what evidence code 1040B2 that I use is for. I've redacted passwords because the government doesn't have to give out passwords to personal computers or to a recurring telephone conference call or anything like that. That's what 1040B2 is. Again, if the point of this hearing is to determine if I've complied with the order of determination, I would just say, first of all, Mr. Sullivan's wrong in saying that I didn't work on the request for 3 weeks after the hearing. I worked on it a lot, and you can see, you go to next request, or I can print out for you all the back and forth with him on what I had my IT team do multiple email searches. That was working on the request. I didn't start releasing things until November 30th. That's correct, because I was trying to come up with a reasonable search term so that I could get him documents he actually wants. So if today's hearing is to determine whether I've complied with the order, again, following the November 4th hearing, we immediately began working to try to get him records. I had our IT team run 4 separate searches for emails. I updated Mr. Sullivan each time on the result, and we began to release records on November 30th. We devoted time every week to Mr. Sullivan's request. I released more than 1,000 records on a rolling basis until we concluded production and closed the request on June 28th. By my plain reading of a dictionary and the order of determination, I've complied with the order. If he wants to continue to harass me and file 3 new complaints, that's something he's perfectly entitled to do, and I'll respond. I've responded to the order of determination. I've given him all the records I can. As far as redacting personal email addresses and phone numbers, that's required under California law, and that is the advice of the city attorney, and multiple city departments do the exact same thing. It's why it takes so long to go and redact correspondence. And I know you're already going to be asking your city attorney about that, but generally when city departments like you, when you say you have something clear that says if you file a complaint, any information is going to be public, people are forewarned and they can come up with a dummy email address or do it anonymously. Someone who's writing into the city or calling into the city doesn't necessarily give up their right to privacy just because they want to say there's trash on the sidewalk. I'm sending an email. They've received no prior warning that any communication is suddenly going to be public. And that's what the city attorney has advised. That's what the state attorney general has advised. That's what the good government guide. But that's a different issue. I gave him the records that we could give him based on how, as good an email search, keyword search as I could do. I really don't know what else I can do in terms of responding to this request. There's where we are.
Thank you for your comments. Member Neighbors, I'm going to hand things back over to you to lead us in questioning. Thank you.
It's clear from some of the exchanges between Mr. Sullivan, you and Mr. Steinberg that you're frustrated with each other, and from your comments tonight that you're frustrated. So I appreciate that you're both here and you're both hanging in and working with us to kind of unravel this and maybe come to an end, so that we can, move on. Because I understand that it is very aggravating and frustrating to keep revisiting the same information. The piece that's a little bit different for me this time, and I think we heard about it in public comment also, is that there is some concern about the kind of ratio between what have been found to be responsive records and the number of records that you have released, Mr. Steinberg. And I was wondering if you could just tell us what is your system for ensuring that you're not engaging in flooding or record dumping in this case? How have you managed that to ensure that you're definitely focusing on giving Mr. Sullivan responsive records?
Well, I will say in general, when people submit records requests, and very often his request is a little different. I'll put it as aside for just a second, but very often we'll get a records request saying, I want all communications between DPW and this company that have the word homeless in it, for example. And I do a search, and if it turns out that there are 25,000 records, I usually will go back to the person and say, there's way more than I will ever have time to review, and you probably don't want all of them anyway. And I try to work with the people to focus requests in some way, by time, by email address, by whatever. And most people are good about working with me on that. In those cases, even if I don't make a determination whether I think it's relevant or not. If they're specifying the keywords, that's how we do the search. In Mr. Sullivan's case, again, I said the easiest thing would be to go to the Green Benefit District Manager and say, give me any emails you have where people were inquiring about establishing a GBD. That was not an option because we didn't have a GBD manager. So again, I try coming up with reasonable search terms, and every time I shared them with Mr. Sullivan, and he came up with some himself, and he repeated back, he wrote back saying, I'm clarifying, this is what you're searching for. So he knew what the search terms were. And I understand, I acknowledge up front that this is not going to be a perfect search. And if you can think of a better way of doing it, I don't know, but this is how we're trying to do it. If it hit with the keywords that we came up with, I released the items to him. At one point, he said, I don't need the attachments. I don't need the graphics because of the way the program works. You get like 5 copies of our logo if there's a string of emails back and forth. So we didn't give them those things. So I was able to eliminate those. So I was giving them basically the bodies of and the text of the emails if they hit those keywords. And again, I every step of the way before I did it, I went over what keywords we were using with them, and we modified them. That's the process we use.
Okay. Thank you. Do you have other questions, members? Charlotte?
This is so just discussion among us. This is again one of those situations that feels challenging because there's not we're seeing efforts to be responsive to what the petitioner is looking for, and yet the petitioner is not satisfied with the response. And it's actually difficult for us to know whether what is being returned is you know, is this everything there is? Or and the question about taking too much time in terms of redaction. This is also a difficult thing to evaluate.
One thing
Mr. Sullivan, did you want to add something?
Yeah, I mean, first of all, my original request is on April 28th, and it's there. You can see it. And then after Sunshine Ordinance Task Force, I specifically told them, don't send commercials, ads. And he continued. And then I just gave up. I just let him go and give up, you know, produce whatever records he wanted. And so part of it is the 4 records that were responsive were a year later. I mean, you know, a year after I asked for the records request. And there was just a lot of other emails, and he didn't have to produce them. He looked at every one of them.
Mr. Sullivan, I have a question, and I know this is challenging because on the one hand, I can see how you said, I don't want commercial ads because you didn't want to be inundated with that information. On the other hand, I could see Mr. Steinberg maybe thinking, if I don't include this, I might get in trouble for not including it. I don't know how to answer that. My question at this point, I know, and as Member Neighbors said, you're frustrated with how long that this took in the first place. From where we are now, is there something that you don't have that you're still looking for?
No, I think that he has given me more than I ever requested. And, you know, he could have just given me the 4 emails.
I see. So so are you saying that the extra
it's a matter of whether you're going to allow this to happen, because it's like, you know, if I put a public record request again to Mr. Steinberg, I mean, are we just going to do the same thing over again?
Let me ask, actually, Mr. Steinberg, I have a question for Mr. Steinberg. Mr. Steinberg, I appreciate you wanting to be precisely responsive to what is requested. When Mr. Sullivan said he didn't want commercial ads, did you, was that something you thought about, or did you think, nope, I'm not going to try to use judgment to apply whether something is a commercial ad or not out of, or tell me what you thought when you got that sort of addendum to the request. Don't send me commercial ads.
Okay, and I just had to go back and look for it. So on December 7th, he sent a message back to me. See, this is part of the problem is, again, we went back and forth a number of times on the different search terms we could use. So for one of them, for example, he said, I want, you know, external. So I came up with, I'll add the phrase something like, this email is from outside of the city email system, so that it would only be external. And the note that he sent on December 7th, where he said, he actually does say, separate search and exclude any BOS newsletters, any advertisement, any dog patch in Northwest Potrero. There's this huge long email that is really hard to understand, and I could send it to you if you really want, but and it was very confusing. And so I went back, and I want to say the same day I wrote him back and said, thank you for your communication. I want to make sure I understood your instructions so there's no confusion. We'll stop processing the files that we previously downloaded, and I'll have IT run a new search. Please confirm that the new search parameters are as follows. And I did keywords this and the message from outside the city, and not Mission Dolores or Dogpatch or Northwest Potrero, and not Jonathan Goldberg. And I basically neglected to put in anything about advertisements. I honestly didn't really see that because it was a really confusing message, which is why I wrote him back and wanted clarification, and I restated what I was going to do the new search for, and that's what showed up. So yeah, I apologize if there were, you know, ads in there that I didn't need to send him, but it was a really confusing email, and that's why I wrote back to clarify. And I put the exclusions, but I didn't include that one in it. So that was my bad. But I mean, I think as I was saying before, usually it's someone, they're asking for specific terms, and I don't make a judgment on whether it's responsive or not if it hits the terms. In this one, we were actually trying to craft the search terms, and so yeah, I would have more, you know, presumably more leeway in deciding what he's really looking for versus what just showed up.
Mr. Sullivan, does that response make sense to you in terms of how, in trying to craft the search in a way that got you what you wanted, how it inadvertently also may have delivered things you didn't want? I mean, does that, I don't know,
No.
Does that help you in any way? No.
No, because first of all, in the beginning, in my initial request, I already told them I didn't want anything of, you know, dog patch or any of the other green benefit districts. I specifically listed that. And second of all, I mean, when he says they're confusing, when you look at the records, I don't format it like a block that he does. Mine is formatted more like he formats his own email. So that they're, you know, it's harder to read my emails. Puts me in a disadvantage. Second of all, if I have to sit around and put out negative search terms, that just makes, you know, he can throw anything at me, which he did, and I have to keep coming up with negative search terms to try and eliminate that. You know, I mean, there's nothing that's like, to me, there's no problem with people asking, inquiring to establish a new green benefit district. That's very clear. If he's looking at a commercial, that is not someone looking to establish a green benefit district. You have to have those actual words, someone inquiring about it. I shouldn't have to come up with a bunch of negatives search terms and keep on to begin with. I mean, this is why I'm frustrated. It's not because of this one. It's going to be the next one where I'm going to have to write some sort of really, you know, long thing where I don't want, you know, this, all the other stuff.
I mean, if I can make a quick comment.
Is that Mr. Young?
Steinberg.
Or is that, sorry, Mr.
Yeah.
Steinberg? Sorry.
I mean, I understand the frustration, but honestly, when I'm doing the keyword search, the fact that there are advertisements in there and the fact that I gave it to him versus if I'd withheld them, that's a really negligible amount of time. I still have to look at them because that's the keyword search I did. He doesn't want the advertisement. That's fine, but if the only way I can do a search is through, if the only way I can do a search is by doing a keyword search, because I don't have a person who can pull files for me, then you're going to get a bunch of stuff that is, you know, not what you want. And again, yes, I apologize. I should not have sent him. I don't know how many there were advertisements and stuff, but it really doesn't take a whole lot more time to send it to him versus moving it into the queue that says non-responsive. I have to look at it in order to determine whether it's a letter or it's an advertisement or anything else. So it's really very little time was wasted by delivering to him some of those things that he didn't want. I mean, I understand he had to look through additional files, but in terms of time, I still had to look at them anyway. So I don't know if that helps.
Okay, thank you. I see Member Neighbors has a question or a comment. Member Neighbors, please go ahead.
That's what I was going to ask you, Mr. Steinberg. I mean, I'm assuming you're having to look at every record to determine whether you need to redact or, if, you know, it's, you know, whatever. So I'm perplexed that you didn't mark those things such as commercial ads as non-responsive. It starts to feel a little bit like you are flooding him or doing a little records dumping. And I think I can imagine that would feel disrespectful in getting that huge stack of records like that. So if it's something that you can change in the future, I think that would be great. One of the concerns, and this is to the members that I have right now, is I hear Mr. Sullivan say that he's worried about in the future what's going to happen when he submits a record request to Mr. Steinberg. And that's a huge problem if he's concerned that there's a chilling climate and that he will receive different treatment and maltreatment because of this issue. I think that's a big problem. And if there are steps that we can take to resolve that or to pave the way for a better outcome, I think that would be great, because that's unacceptable.
Member Wong, any thoughts on this, or?
No, nothing in particular. I mean, I think I agree with both of you. This is one of those tough situations. I think in response to what Member Neighbor said, I think the hope is that by having both parties here, it means that going forward, records are produced in a way that makes sense for the requester and the respondent. I mean, I guess that's always the hope, really, with the entire task force and this committee. So,
yeah, I agree. And here, I'm going to say something here. So, Mr. Sullivan and Mr. Steinberg, you know us, we know you, because you do engage with the task force, and we appreciate you being here, even though you're on opposite sides. And we want, we're trying to do our job, and we're trying to help members of the public get records they're looking for. And, Mr. Steinberg, I think, is trying to help to respond to requests and help people get the information they need. In this particular situation, maybe our committee can provide some mediation services here, because I think you would both rather spend your time getting the records you need or fulfilling records requests and getting responsive answers and being responsive in delivering records, rather than spending more and more time with us in successive compliance meetings, even though I know you really like us and this is a lot of fun. I think it would be in everyone's best interest to take the situation and let's learn from it. I think based on Mr. Steinberg's recommendations, I think Mr. Sullivan is learning how to craft more concise requests and being very specific about what he does and doesn't want. Perhaps Mr. Steinberg can also learn from Mr. Sullivan in terms of, even if the request is very long and detailed, confirming what is being sought. And if something seems, if what is being returned does not seem responsive based on what the original request or intent was, maybe going back and asking again, do you really want these ads? I know that may require some judgment, but as you've said to us before, you depend on petitioners to help you narrow down the searches. And I think for both of you, because this is probably not going to be the last time you interact with each other, I think it's in everybody's best interest if we can all learn from this situation. And I understand the frustrations on both sides, and we want to help mediate as much as we can. So if there are other things you think that we can do to help you work more effectively with each other and have less frustration, we are happy to do that. I will ask at this, yes, Mr. Sullivan, at this point.
Can I ask you a question?
Yes, and then I want to ask you what we can do to help you.
Okay, well, that's what I'm going to ask. So, getting back, so number one, I have not learned anything about crafting a better public record request from this incident. So number one, any records as to inquiring into establishing a green benefit district from April 29, 2019 to today outside of the Inner Sunset Mission Dolores and greater Buena Vista neighborhood efforts. How would you make that better?
Let's ask Mr. Steinberg. Mr. Steinberg, Mr. Sullivan wants to work more effectively with you. What would be the best way for him to submit requests to you? And you know he's going to come back. Let's make this easier for everyone. What can he do in submitting his requests to you to get more responsive records and to limit the work that you're required to do in seeking out those records?
Okay. First of all, thank you for the suggestions. I appreciate the idea of trying to get this right. The best thing that any requester can do to get what they want and get it in a timely manner is to tell, ideally tell you exactly what, if there's a specific document, tell me what the document is. Unfortunately, in cases like this, it's, I want anything that shows or anything that is about, and those are really difficult. I honestly don't, I think we really did try to do a good job of coming up with something that would find the things he was working for. I got creative, at the point that I realized that when he said he wanted it, the more information he gives me, the better. And he did that. It's like, okay, I want it as external. I want, this, and it's like, hey, I came up with a brilliant idea of including the phrase that shows that an email is not from the city's email service. So anything like that, but I think what was frustrating was that it seems like we went back and forth, and every time we tried tinkering with it, it's like we went 2 steps forward, 1 step back, or sometimes 1 step forward and 2 steps back. And that's why I think the search came up with such wildly different results, is because we kept tinkering with them. And I don't know. It's part of the problem, as I sort of said earlier, is I'm in a lot of these, because this is a different type of request. If someone's asking for something with certain keywords, which is not the case here, then I'm going to give it, I don't make a judgment of whether it's responsive or not. And so part of me is, I'm in that is my mindset when I'm doing these, is like, okay, if the IT results pulled this in, then it has these words somewhere in it, even if it's in an attachment. Chair LaHood applied, I was a copy editor for 25 years. And so it's like, here's what the rules are, here's what it is. That's why I follow them. So maybe it's a little too dogmatic, and I understand that. So in cases like this, yeah, working with the person to get the results they want is the best way of doing it. And again, I do that with people all the time. And sometimes people do it, they interject before I even have a chance. It's like, okay, you gave me all of these. This request, I want you to search the same terms, but exclude anything that has the subject line SF tent count, because in their previous 5 requests, they've noticed that there's a daily email that goes to 12 people, and they don't need to get 12 times 30 every month. And in other cases, I will try to suggest things when I see certain things, like, oh, I've found this a number of times. You probably don't want to get that. I can exclude them. And that's the best I can do. That's the best way I can, offer, is to try to work with folks to get them what they actually want.
So again,
Hang on one second. I'm sorry.
Okay.
I'm sorry. I was speaking, but I was muted, and I realized you couldn't hear me. Mr. Sullivan, I have one more question for you. I know in this situation you've been frustrated, and I know you've had some other frustrating experiences getting information from the city, and I want to acknowledge that. Can you have you had some less frustrating experiences, and was there anything that would distinguish those that might be helpful for us here, regarding either how somebody worked with you in terms of narrowing down a request that might help improve the relationship with this particular department?
Mr. Steinberg is the only person that I have difficulty with. This is why we're in here constantly. And I just want to say that he never suggested like, oh, I come up with these commercials. I know you don't want those or anything like that. The only thing he ever did was give me a number every time I made a suggestion. He still hasn't actually. I mean, it's real easy. If you take inquiring into establishing a green benefit district and put add signs into the a plus sign in between each of those words and put it in your search thing, or you put in start, a green benefit district and put plus signs, you won't get all these emails. You'll just get those 4. He still has not yet said how he could make this request better.
Okay. I appreciate both of you giving your perspectives on this. I think I want to bring it back to the members, and I would just encourage both of you, because you're going to be working together again, if you can have some patience with each other, because I think you'll both get more of what you want and less frustration if you can just have some patience. And I want to acknowledge that I want to acknowledge that there's frustration on both sides, and I don't want to diminish that. But I also want to make sure that you you both get more of what you want in the situation, because I don't necessarily think that the things that you're both looking for are not necessarily mutually exclusive. That's the end of my commentary. I'd like to bring it back to the members for discussion and to find out how you'd like to proceed. And actually, I might hand it back to member Neighbors. Do you have a recommendation for us here?
I think at this point, it seems like Mr. Steinberg has produced what he is going to produce, and it probably is the most humane thing for us to consider this a closed matter and move on. With that caveat of, it's too bad we can't, if you come together again in the future and you have a really successful search process together, you won't be in front of us telling us about it, so we'll never know. But I'm going to hold out hope that the two of you are able to do that in the future. But I think this matter in and of itself, to me, seems to be at the end. I'm open to arguments otherwise from members, for sure.
Member Wong, any other thoughts on this? No. I'm just going to ask one more time to make sure, but Mr. Sullivan, when I had asked you previously, is there anything else you're looking for? And you previously said no, but you were frustrated with the volume of documents that were returned. I just want to make sure one more time that we're not leaving anything behind that you may have requested and not yet received. Can you confirm that for me?
Yes, and I wasn't frustrated. I'm sorry, I just worried about the future, but I don't have any more documents that I need from him right at this point.
Okay, thank you. I appreciate that. And I hope that the extension of this conversation can help you to work together, because I know you're going to be working together again. And we want it to be a more positive experience if that's possible. And that's not to say that there aren't going to be more requests. This is not to diminish the enthusiasm for making requests. This is just to see if we can help you work together more effectively so that you both get more of what you want.
And feel free to drop us a line if you have a good experience.
Yeah, that would be awesome. So, on that note, members, it sounds like we don't have a motion on this, but since we spent a lot of time talking, although I don't want to stop anyone. If anyone has a motion, I want to hear it. Otherwise, I would like to open this up for public comment in case anyone has comments on what we've discussed today. Okay. Mr. Young, we would like to open this up for public comment. If anyone is on the phone and who's not party to this matter, who would like to make public comment, you can press *3 to enter the speaker line. If you are on WebEx, you can raise your hand. Mr. Young, do we have anyone who would like to make public comment on this item?
It appears we have one person with their hand raised. I'll unmute them at this time.
Thank you.
Good evening, Commissioner members. This is Lisa Morowski, and I would like to make comment about when the requester asks for records and the file flooding that we receive and the timely manner. It always falls on the burden of the requester. And I find it very entitling that someone can say that your perception of how something should be worded should look at a perception of how someone's ask is. What gives you that right? So again, really selective, privileged. I can't imagine. I know it because it's happened to me. I've been sitting in these rooms for now, let's see, now 18, 19, 21, 22. It's going on 5 years and still have not received my records based on either I submitted something wrong or I did not word this correctly, or 3 times I've had to prove that something was contracted to the department. The burden is insane when all the public is trying to do is to protect others. They're advocating, they're asking for records, they're asking for proof. And I don't know why it has to be so difficult and such a burden. And then the other side, they can have loopholes, they can flood you, they can, oh, I thought it was this. The delay, 5 years, the delay that you go through, what is your hope? So it's time to move into the 21st century and realize that ageism, youthism, and the privilege of technology and the cost factors in putting evidence together, the trauma that it causes, that just going this back and forth, it's not a healthy. So I find that in violation of a service by the Sunshine Ordinance Task Force. Thank you. I yield the rest of my time.
Thank you for your comments. We appreciate it. Mr. Young, is there anyone else in line who'd like to make public comment?
That does conclude public comment. I do suggest that some type of motion be made to conclude this matter, if that is your decision to make.
Would someone like to make a motion to conclude this matter? I guess unless member neighbors, did you want to make a motion?
So we don't say that we close the file. We just simply say that I move that in the matter of file 21-069 that
Can I suggest that they've complied with the order of determination and
Sure.
to close the matter?
That's what I was thinking. Yeah, that sounds great. So in the matter, yeah, the David Steinberg and the Public Works have complied.
And do we have a second?
Yes, this is Member Wong. I will second.
Okay. Since we've made a motion, I will open up for public comment again.
Just a second.
Okay. Sorry. I'm going to give Ms. Leger time to document the motion.
Member Wong, you were second?
Correct.
Shall I read it? Moved by Member Neighbor, seconded by Member Wong, that in the matter of 21-069, that David Steinberg has complied with the order of determination.
David Steinberg and the Department of Public Works.
Okay.
And I believe Mr. Young suggested that we add and that the matter is closed.
If there are any members of the public who would like to provide public comment on this matter, You can raise your hand at this time by pressing *3 or otherwise using the application to raise your hand. I do not have any indication of additional public comment on this matter.
Okay, thank you. Ms. Leger, please call the vote.
Member Neighbors.
Aye.
Member Neighbors, aye. Member Wong.
Aye.
Member Wong, aye. Chair LaHood.
Aye.
Chair LaHood, aye. Moved by Member Neighbors, seconded by Member Wong, that the matter of 21069, that David Steinberg and the Department of Public Works have complied with the order of determination and that this matter is now closed.
Okay, I want to thank Mr. Sullivan and Mr. Steinberg for being here today. We appreciate your participation. And Ms. Leger, please call the next item.
Okay, Item number 9, file number 22092, hearing to review the Behavioral Health Commission's compliance with the Sunshine Ordinance for meetings that occurred after April 13, 2021. On April 6, 2022, the task force referred the matter to the Compliance and Amendments Committee to monitor future Behavioral Health Commission meetings for compliance with the following sections of the Sunshine Ordinance. 67.7A as an apple, providing an adequate description of the agenda items. 67.7A as an apple, posting agenda 72 hours in advance of the meeting. 67.7B, providing a clear description of agenda matters. 67.7B, posting supporting documents online or making them available as soon as they are available. 67.7G, including notices of rights under the Sunshine Ordinance on the agenda. 67.9A is an apple, posting supplementary documents for the meeting on the internet. 67.15A, following public comment for each item on the agenda. In addition, the task force requests that the Behavioral Health Commission provide their manual or description of their procedures, practices implemented to address the code sections listed. In an effort to document compliances with posting requirements of the Sunshine Ordinance, the task force requests that the Behavioral Health Commission maintain a log of when agendas and supporting documents are posted along with other relevant data.
Okay, thank you. Do we have a representative of the Behavioral Health Commission here?
If there's anybody participants in this matter or representing the petitioner or the respondent, you can raise your hand this time. I will unmute your microphone. We have Mr. Greer who has raised his hand. He is unmuted.
Yeah, I just wanted to clarify that I am not the direct representative of the Behavioral Health Commission any longer. That we are in the process of transition. Clerk Gray, who is online, I'm pretty sure she's probably having some problems getting on to be heard. I know she's online because we've been communicating. So I guess I'm trying to buy time until she can come up and make a statement.
I see
Hello?
someone. Hello?
It's Amber. Hi.
Oh, great.
Okay, good. Go ahead. So if you need me, you let me know.
Thank you, Mr. Young.
Okay, so we have Clerk Gray. And is Mr. Hillier here?
Present. Present.
Okay. As we had some correspondence back and forth about what we were going to be reviewing today. And this is not a hearing per se, but a chance to review progress so far and to see what else we need to do. We did receive an extensive submission from Mr. Hillier with his tracking of what's going on with the Behavioral Health Commission and these issues that are part of file 22092. there's a lot there that we can speak to. I would like to, let's see, how do I want to handle this? I would actually, because this is not a hearing per se, I would actually like to hear from the Behavioral Health Commission first about how they have been addressing these matters and where they think there have been some improvements. And then, Mr. Hillier, I'm going to talk about what I read from your presentation and then get some of your feedback on this. There were so many detailed items. I don't necessarily want to go, I do not want to go item by item because that would take us too long, but I want to speak to the spirit of what was brought up in each of these sections. So will it be Amber Gray who is speaking for the Behavioral Health Commission today?
Yes, ma'am, that would be me.
Okay. I just saw Ms. Leger step away. So we're going to wait for a moment and not proceed yet. I think. Thank you for your patience. I'm sorry about that.
Sorry, I have to go let my roommate in. I'll be right back.
Okay.
You can proceed. I am here.
Okay. We have Mr. Young. If you could fill in for the moment, that would be great. Yes, Clerk Gray, we will give you a chance to speak. Mr. Young will set the timer, and you will have, you know what I'm going to do? I'm going to give you 5 minutes to speak because there's a lot to address here, and I want to make sure that we give you enough time. And then we'll hear a little bit from Mr. Hillier. Actually, you know what? I take that back. I'm not going to set a timer.
Okay.
Mr. Young, we're not doing a timer here because this is follow-up. So please go ahead and give us as a concise and relevant update as you can. Thank you.
Thank you. And basically, I am a fairly new staff. I am just onboarding in March. I'm still in training, which is probably some of the connection difficulties with connecting to who you need to connect. I am the person that will be responding. However, there will be some things I won't be able to answer on my own. However, since I've been at the commission, there have been multiple changes in the structure and team building efforts. We have just completed a training on Saturday with the California Association of Behavioral Health Boards and Commissions. We plan to continue to get training and support from Teresa, and when we have problems, we want to stay solution focused. And we have updated our bylaws and with the plan to develop a procedure manual that I will develop myself from our efforts of training and delegating different tasks to our commissioners and understanding what our roles and responsibilities are. And we will be reviewing continuing to review the Brown Act as well as Sunshine Act and doing our best to get adherence. And as far as the allegations go, we have had 1 or 2 times where there was a missed posting. However, we are currently switching over transitioning from sfdph.org to sf.gov platform has been caused multiple challenges. And responding to, okay, I can't hear you.
Oh, sorry. I apologize. I had the mute on. I was going to say, is there, thank you. I know you said you just took over in this position. I wanted to ask if Mr. Greer has anything else to add, if this was a very recent transition, anything else that you'd like to add before I ask Mr. Hillier to speak?
Yes, it is. Well, I would like to say that in responding to these sunshine ordinance, it has taken away from the actual business of the commission and building of the commission. When I came there, it was in disarray as somewhat, and we all worked together collectively to try to put things in order. And since I've been there, I've heard a lot of negative stuff from one person, basically. I won't name names, but basically, no one else is complaining about agendas or anything that has to do with the commission. So I can assure you that we are making every effort to do what is right and according to the Brown Act and Sunshine Ordinance.
Okay. Thank you for your comments. It sounds like that's sorry, go ahead.
Some of the comments and some of the behavior is intimidating and threatening, and it sometimes goes beyond feeling safe. For me as a trans woman of color, safety is important, and I think it's important for community. And if I'm addressing the public, and I've been in public health many years, I know how to deal with the public. When somebody starts making threats and telling us to be aware of what I'm going to do to you and stuff, I start having nightmares. And I just want to say that that's basically it. I want to feel safe. I want the public to feel safe. And I want to be able to build this commission to something great and do the work. And that's me coming in the door.
Thank you, Ms. Greer. We are, just to be clear, we are here to help you, because that is our job, is to help members of the public make sure they get access to records and meetings as they are recorded by law, and to also help people who represent the city comply efficiently and effectively with the Sunshine Ordinance. So I don't know if you were here for the earlier part of the meeting, but we also can provide some mediation for members of the public and representatives of city agencies, because, as you know, you've said, you're often working with the same people over and over, and we want you to have a good experience working with each other. And I'm sorry if you've had any negative experience, and I hope we can help with that. I also want to make sure that we are representing members of the public effectively to present, their concerns to the city and city representatives. So I'm going to switch over, and we want to hear from Mr. Hillier, who is very much interested in the Behavioral Health Commission and has been tracking activities and agendas and lots of things on that front. Mr. Hillier, I'm not going to set a time limit on this, but could you give us sort of a concise summary, and then we will go into, I'm not going to go into, as I said, every detailed item, but I do want to hit some of the bullet points that are in our agenda to have, a little conversation about that and see what the Behavioral Health Commission may have already done, or what Ms. Gray intends to do on that front, knowing that we are not planning on resolving everything today. We decided to discuss this at this meeting, knowing that there wasn't going to be time to prepare full responses, in part because of recent transitions happening at the Behavioral Health Commission. But we also did not want to delay, because we want to make sure that we continue to see progress. So, Mr. Hillier, I will give you the floor.
Thank you, Madam Chair. So the agenda item is a little bit misleading, because there actually have been more than one adjudication by the task force on this issue against the Behavioral Health Commission. The task force ruled essentially substantially the same ruling against the Behavioral Health Commission on October 6th of last year. And then they fortuitously reaffirmed that ruling on February 2nd of this year, leading up to the April 6th ruling that's on the agenda. These violations have been going on since July of 2020, and we filed our first complaint on July 18th of 2020, over 2 years ago. And for all this time, and this is the 10th hearing before the SOTF and or its committees on this issue. And for all of that, thousands of pages of documentation, probably close to $1,000 spent out of my pocket. We've gotten very little. We've gotten Know Your Rights Under the Sunshine Ordinance pasted onto all of their agendas. And we've got many more opportunities for the public to address the commission and its committees on the agendas. But this has been all, and there has been backsliding. Compliance has gotten worse in other areas. Section 67.7A, failing to post the agenda 72 hours before the meeting. There were 4 violations just this month of it. And I produced evidence before them. I sent them email ahead of the meeting. They just go rolling right along and hold their meeting like nothing is wrong. Like there is no problem. They seem to lack any will to comply with this section. 67.7A, again, failing to provide adequate description of their agenda items. There was a little progress in this area after the first ruling last October, but then they backslid, and now they're as bad as ever. They just put update on their agenda items that they copy from one agenda to the other. 67.9A, failing to post supplementary documents on the internet. They have yet to post a single document. It is quite possible for them to post a document on the internet. They share the same website as the Health Commission. And the Health Commission posts all kinds of documents related to their meetings on their website. BHC can do the same thing, and they can do it now before transitioning to sf.gov. Compliance with 67.15A, while I said that it has been improved in some ways, has also, still very bad in other ways. Many items on the agenda still have no opportunity for the public to address the commission, or the agenda shows the opportunity is coming after a vote on the item will have been taken when public comment is futile, or the opportunity shown on the agenda is not actually called at the meeting, or the members of the public are given 1.5 minutes to speak thereon, half what is required by another subsection of this section. And it particularly want to emphasize 67.7A boilerplate agenda items. We complained about this in our very first complaint. The SOTF ruled in our favor, and the problem has gotten worse. They are now multiplying the boilerplate type agenda items until a lot of agendas now are completely, almost completely boilerplate. It's completely stuff, or it's predominantly stuff just copied over from the previous agenda, which was copied over from the agenda before that and before that and before that. And the meetings are really becoming silly, because most of those items are dead in the water. No one has anything to say about them, and so they're skipped, and the public is badly misled by this over-noticing because we think we have an opportunity, we think an item's going to be discussed, we think we're going to have an opportunity to comment on it. It's not discussed, and there's no opportunity. And the same item keeps showing up month after month after month after month. So you don't know what meeting you should go to if you want to have an impact. And so that pretty much sums it up. Back to you, Madam Chair.
Okay, Mr. Hillier, thank you for your comments. I'd like to come back to Ms. Gray and talk about some of the items as we have them listed on our agenda. I will note that one, we can cross off as it looks like we've got full compliance now on including notices and rights under the Sunshine Ordinance on the agenda. So that has been taken care of as the Sunshine, part of this, a committee of the Sunshine Ordinance Task Force. We're happy to see that. It looks like a lot of, almost a good portion of the challenges that we're seeing brought up here have to do with the creation of agendas, the posting of agendas, and the descriptions placed on the agendas. Ms. Gray, are you, I know you're new in this role. creating the agenda is going to be your responsibility, or is this someone else who is part of the commission who is responsible for creating the agendas?
It will be my responsibility. I'm currently in training.
Okay, so you're in training, and
when we
yes,
we attended a training on Saturday, and it was expressed to us that it takes about 2 years to be fully acclimated in the position. But
okay.
we have, I mean, I feel like I'm having progress.
Mm-hmm. Do you feel as though you have a clear understanding of how you should be describing items in the agenda? Was that part of the training you received? And are you receiving additional training from either from supervisors in your department or supervisors from the Behavioral Health Commission or other city departments who are helping you in terms of knowing what needs to be included in agenda item descriptions?
Yes, Mr. Greer has been helping me with that.
Okay. Regarding posting the agenda 72 hours in advance of the meeting, you mentioned the transition to the new website. I don't know if you or Mr. Greer can answer, when is that transition expected to be complete? When will the commission be entirely on sfgov.org?
Yes, I think that would be more of a question for Mr. Greer.
Okay, Mr. Greer, could you answer that question?
Can you hear me?
Yes.
Okay. Yeah. This whole process, conversion from dph.org to sf.gov, has been, plagued with several problems. It had several bugs. We're looking at going live possibly the middle of September. We had planned to go the end of July, but we are looking at possibly going live the middle of September.
So middle of September is about a month out from now, and that would be about halfway between this Compliance and Amendments Committee meeting and our next one, which will be in October. That's good to hear. Let me ask you, Mr. Greer, once that new website is up, how easy will it be to post agendas?
Theoretically, it will be extremely easy because right now, I don't know how well you're familiar with the process, but there's about a 3-level process that has to go right now. The agenda has to be created, has to be reviewed, it has to be sent to IT. IT has to send it to another individual who does the actual posting. Then they send a notice back to me. That means it can't get posted until after 5. Then you can finally review it. So if there's a problem, you don't have time to go back and say, hey, wait a minute, I think we missed something, or we need to add something. It's done. It's just in the machine. So I believe that, and from what I've seen and the work with the sf.gov, it is a direct upload, and it will streamline things immensely. It would be immensely helpful, especially for us, because we have so many meetings and so many postings.
Okay. And Mr. Greer, it sounds like you have knowledge of and are involved in the technical aspects of these agendas getting posted. Are you also involved in reviewing agendas?
I'm involved in reviewing and helping to construct them as well.
Okay. Maybe if you could comment a little bit about, Ms. Gray said she's getting some, is just starting, is getting some training. Can you talk about what the commission is doing to improve the clarity of its descriptions, and maybe talk a little bit about, sort of copying items from one agenda to the next, which sometimes, is what needs to be done because there's continuity of items. But what are you doing to make sure that there aren't just sort of broad categories being used to describe items when there should be more specific descriptions on the agenda?
Well, that's very difficult because, as you've probably gathered, we only have one individual that seems to be plagued by this fabricated problem. The agendas are sent to the co-chairs who review. say, okay, that's fine, add this, subtract that, and we post. There's a lot of times that there's unfinished business or there is an item that needs to be continued, and it will be a copy paste and put back on the agenda for the following month, or it'll reoccur. Or some items are ongoing. For instance, the strategic plan. Yes, the strategic plan has been requested by that chair to be on the agenda because it's a live document. It's a live working piece. We always want to discuss it. It's not done after one meeting. So I think Mr. Hillier's personal perturbance with our process is specific only to him. We have the Behavioral Health Commission is probably the largest vehicle for the public to air their grievances, air their choices, air their specificities. And it's an opportunity. We relish the public. We want them to be able to speak. We want more people to come. Unfortunately, they are intimidated. The threats of being taken to court or being charged with some erroneous crime for attending our meeting threatens people. They feel intimidated. But more to your point, Mr. Hillier sends out erroneous emails and threatens people. But what I'm saying is that the agendas that, and I can only speak to him because nobody else is complaining. The only time we run into an issue where the description of the item on the agenda seems to be very general, or it's unclear, or I don't know, is only one person repeatedly. And I don't know who is we. Does he have a team? Is he working for the Sunshine Ordinance Task Force? Is he an agent? I don't understand.
So the Sunshine Ordinance Task Force takes complaints that we receive seriously. And we actually, sometimes we get complaints from people who have never filed a complaint, and sometimes we get complaints from people who are familiar with the Sunshine Ordinance, with the task force and the work that we do. We don't pick favorites. We try to represent members of the public. We represent members of the public in the request to seek access to meetings, access to public records as they are allowed to do by law. We are trying to do that dispassionately and not to be concerned with the content of the request, but to make sure that the requests are being taken seriously. And we try to work with departments and city representatives to be responsive to the Sunshine Ordinance, to requests made through the Sunshine Ordinance and the California Public Records Act. That's why we are here today. As I said earlier, we also, I think, especially with committee, because it's about compliance, if we can also help mediate between individuals and departments so that we can save everyone more time and energy, because I think, you mentioned Mr. Hillier is looking for access. He's looking for records. He's looking for information. He's looking for clearly posted agendas. And I know that you and your team are trying to provide information for the public so that people can participate effectively.
Absolutely.
And also, you don't want to go around in circles and make more work for yourselves. So I understand both sides, and I think my committee members do as well. And I do want to give them a chance to ask some questions because I've been talking a lot tonight. But my goal is to help you so that you get to spend less time talking to us, not more. Because even though, we want to talk to everybody who wants to be here or needs to be here, but at the end of the day, we have a lot of work to do, and we want to get through this efficiently. And I would say, I know you want to focus on the work that you're doing, and I think you'll be able to do the work more effectively and communicate with the public more effectively. Even though it may seem in the short term, like, is this adding a layer of work by writing longer descriptions or by linking to posting more information along with the agenda online? it may be more work in the short term and less work in the long term. Before I keep going, I actually want to ask.
Well, Chair LaFleur, could I say
yes.
something?
Yes.
Yes, I agree. And, I don't, I'll take my foot off the accelerator. I just wanted to kind of put it out there as to, what's going on. If you'll allow me, I could run through these items very quickly and say what the remediation of each one is being done.
Okay, that sounds good. Let's hear that. And then I do want to give my fellow committee members a chance to ask their questions as well. But yes, if you could do that, if you could go through the items and give us an update about what you're doing or what you plan to do, that would be very helpful.
Okay. So item 1, 67.7A, providing an adequate description of agenda items. We are trying to, as in training with Amber as well, or Clerk Gray, we're trying to be a little bit more detailed. However, we're kind of caught in a quandary because as staff, we are charged with creating an agenda. The process is the agenda goes to co-chairs who review and say yay or nay, add or subtract. If we receive an agenda back that they say, fine, go forward. Well, we've got about 20 pages of minutes to do also. So we take their note and say, okay, they're happy with the agenda, and it proceeds on. So that's that piece there, but we will be more detailed and take a larger step in adding more detail to the agenda. Posting the agenda with 72 hours in advance of the meeting. I think that's pretty self-explanatory. We missed maybe 3. Out of all of the postings that have been done, I think maybe we've missed 3. And 2 of them have been due technical issues. IT couldn't do it, then somebody wasn't there, something to that effect. So, and it's not deliberate, it's not purposeful. We take a very, very, it's a high priority of making sure that 72 hours is met. So I don't really feel as though too much, given the odds, on a perfect day, if you got 2 years and you missed 3 filings, I think you're doing pretty good. 67.7B, providing a clear description of the agenda matters. Once again, this sounds like a redundant of the first one. It's the same deal. I mean, we do our best to provide the description as stated by the co-chair or chair. If they're satisfied with it, we've been proceeding on. We'll take the impetus to add more detail ourselves. 67.7B, again, posting supporting documents online or making them available as they are available. We post all of our agendas online. All the documents are there, sfdph.org. You can go there, you can see, you can go all the way back to 2000 and see all of our postings. So I really don't know what he's talking about, or they are talking about. He keeps saying there's a team. 67.7G, including notices, rights under the sunshine. Well, we took that off. 67.9A, posting supplementary documents for the meeting on the internet. Once again, we post everything that we have. I'm sure there's been a few items that may have been missed, but they're discussed and acknowledged within the meeting. I need more clarity on that. We will do our best if it's really something that we've been lacking on. And then finally, allowing public comment for each item on the agenda. Now, I don't know if you've taken the time to look at our agendas, but it is flooded with public comment. We endorse and we believe that the public should have an opportunity to have comment. We relish it. So, short of showing you one of our agendas and you can see where the public comment is, I don't know what else we could do. Maybe it's placed in the wrong way. And I do know that during the training, they did emphasize where public comment should be in each item on the agenda. There are some things that conflate into 2, like you have 2 or 3 items that are discussing the same subject. Maybe we compress them and allow public comment at the beginning and at the end for those 2. Perhaps that's what they are talking about. Other than that, have no knowledge. Anyway, those are all the items, and we take great pride in trying to improve the quality of the Behavioral Health Commission as a whole.
Thank you for going step by step through that. I appreciate that. I'm going to open it up to my fellow committee members. Do you have questions or things that you'd like to hear more about, either from our Behavioral Health Commission representatives or from Mr. Hilliard?
This is Member Wong. I guess I have just one question. I know your goal is to go live by end of September for being able to manage agendas.
September 15th.
Okay. So you have an actual date as well. Okay. Yeah, that's my question. Thank you.
Mm-hmm.
Hey, so I had a question in terms of on the this is member neighbors on the for the meetings in which you missed the deadline, the handful of meetings for which you missed the deadline for posting the agenda. Did you go ahead and have those meetings, or did you cancel those meetings until a time when you could post the agenda with sufficient advance notice?
Those meetings are either canceled or they are relegated to a work-only meeting. No voting. There can be discussion. And that is clearly stated at the beginning of the meeting, and all participants are fully knowledgeable. This is not a voting meeting. This is not an official meeting because we missed the deadline. We explain everything. We put it all out there. We missed the deadline. This really is not an official meeting, but we can discuss what we're going to do, and that's it. It becomes a working meeting.
Yeah, rebut.
Sure. I will take a brief response.
Okay, I'm not aware of any meetings that have been canceled in the entire 2-year period because of this reason. They do sometimes will have a meeting in discussion only mode, as they call it, and that is a violation of 67.7A because it requires each item on the agenda to be labeled with either the action, the proposed action, or a statement that the item is for discussion only. So all the action items become discussion only items. That's not the only time they do this. And furthermore, it's only because the criminal penalties of the Brown Act, Government Code Section 54.959, only apply to action taken. So they're just ducking the criminal requirement, the criminal penalties of the Brown Act. They don't recognize that it is still a civil violation of both the Brown Act and the Sunshine Ordinance to hold a meeting at all with a quorum of the members talking about stuff within the subject matter jurisdiction or views on anything else with respect to the Sunshine Ordinance. And that is a violation of the law. Back to you, Madam Chair.
Thank you for the comment. I have a question, Mr. Greer, regarding 67.7B, posting supporting documents online or making them available as soon as they're available, and also 67.9A, posting supplementary documents for the meeting on the internet. You mentioned specifically the agendas, and you said, with the exception of the 3 where there were technical delays, that you get the agendas posted. What about other supplemental information that might be related to the items on the agenda? Are you
such as?
So with our agenda for this meeting, there are and I don't know how closely you looked at it, but if you look on each agenda item and it says attachments, and if you click on attachments, it goes to many, many, many pages. Are you doing this with your agenda, and are you including relevant documents with items for which there are relevant documents?
Right. If there's an item that will be discussed during a meeting, it is attached in the agenda. If anybody chooses to, perhaps one of the chair people that are here, they can go on to sfdph.org or whatever and go to our meetings. You can pull up any one of our agendas, page through. You will see the attachment, for instance, of the bylaws. When we're discussing the bylaws, the entire bylaws are included. If we're discussing a resolution, the entire resolution is attached. If we're discussing, just like Mr. Hilliard was referring to, copy and paste, for instance, on the strategic plan, because the strategic plan is an ongoing item, it's always attached. Those items are always attached. Supplementary material is always attached to our agendas. Have there been a miss? Probably. You know, is it minimal? Absolutely. If I were to give a percentage, I'm saying we're about a 95, 96% hit rate. You know, we may miss it, 2 or 3%. That's all I'm trying to just be humanly fair. I couldn't even go back and tell you. I mean, we always make a point of attaching supplementary material. So,
and how many meetings are we talking about? If full commission and committee meetings, because you're referring to it as if it's a lot of meetings. So how many are we talking about per month or per year?
So we have standing meetings 4 a month. Okay, so we got four meetings a month. So you got to include the minutes, and ad hoc can take place at any given time in any given place. So we'll have other meetings in between there that are ad hoc meetings that are not necessarily planned. They're short notice, so we have to make sure we get that 72-hour window. And then to address, I'm just going to back up a minute, to address the fact that we shouldn't be having the meetings. It shouldn't be a working meeting. It shouldn't even be discussed, unless each item is clearly identified as this is a discussion only. If a agenda has been filed by us and for some reason has not been posted within the 72-hour window, I, in good conscience, can't go back and change that document and say, oh, this is going to be discussion only. We can make that announcement at the beginning of the meeting under agenda changes and clearly state that because of a failure to meet the 72-hour window, that we can only discuss this item, or failure to include something on the agenda, it can't be discussed. But I can't go back and change something that's already been posted or set for filing. So hopefully that answers that.
That does.
Sure.
I'll take a brief response.
Okay, thanks. Just regarding the attached items, VHC uses I've complained adequately in the complaint that the attached items aren't always clear, because sometimes there's too many attachments and the public can't figure out which thing goes with which item on the agenda. But they never have posted my correspondence. I often send them correspondence in advance of the meeting, relevant to an item anticipated to be discussed, and it has never been posted. And I filed a 286-page exhibits exemplifying that. Back to you, Madam Chair.
I'm going to bring this for discussion with my fellow committee members. I thought, and perhaps we can have a brief discussion about this, that if someone wanted to submit public comment of up to 150 words in text in advance of the meeting, that was to be added to the agenda. And I know with different departments and agencies, there's the perennial debate about whether it must be included in line with the agenda item or if it's okay to attach them at the end. And that was something that, but I know that has come up before, and 150-word comments submitted before by the deadline for posting the meeting are supposed to be included. I'm not sure that members of the public are allowed to submit whatever they want on items that they are not party to, and expect that they will be attached to the agenda. What is your understanding of that?
Chair,
Me or Mr. Dreyer?
Hold on one second. Yes, Mr. Young?
In regards to the 150 words, that's after the meeting, not prior to the meeting.
Okay.
Because that's public comment. If they're not there to present their public comment, they're not allowed to put it into the minutes. In regards to public comment provided in advance of the meeting, generally I would put it into the packet, but there's a timing issue in that if it comes in after everything is published, it can be difficult to get it online in a timely manner.
Right. No, so just to clarify what you're saying, if someone, oh, I see, because the agenda, by the time the agenda is published, unless you know something's going to be on the agenda and you submit public comment in advance, it could be included in the packet. But if it's after the agenda is published, any public comment that you submit after the agenda has been posted would then be attached to the minutes. Is that what you're saying? Yes, I'm getting nods. Okay, and Mr. Young, I don't. Oh, Mr. Young, I think you're muted. I just wanted to clarify with regards to someone who is not party to a particular matter being discussed, submitting a document that is longer than 150 words. Is there any promise or expectation that that would either be attached to an agenda or minutes?
In general, they become part of the file. It may not be specifically part of the minutes, but it would become. I can only give you Board of Supervisor practices. If we receive documents related to a file after the meeting, we put it into the file. It may not show up on the minutes, but it will be made a part of the file. In regards to receiving it before the meeting occurs, we do try to post those as soon as possible, but because of timelines and it's hard to know how long it'll take us to get it online.
But when you say it would become part of the file, so if there was an agenda item that was addressed in more than one meeting, if somebody submitted commentary between meeting 1 and meeting 2, it would be added to the file and then would appear with documents that were associated with the item in meeting 2.
Agencies would, excuse me for interrupting, that would be a policy that individual agencies would need to develop.
I see. So there's not, okay. That's
Chairman
up to
Hood?
me. Yes.
Chairman Hood, I just wanted to say that, and you know, I and Amber and the entire Behavioral Health Commission are open to education, change, all of that. My training and my understanding, even as recently as this Saturday, was that the minutes and public comment is to be summarized. That is my understanding.
I can speak to what the task force does. Our minutes are not verbatim. They are action minutes. On this date, the petitioner submitted.
I don't think we need to describe our practices, but I believe he agrees with us that they are summary minutes.
Right. So I just want, this is an interesting discussion. I would like to look into and look back, because I remember that the task force has had conversations before regarding the submission of 150-word public comment statements. And I unless members remember specifically what, and again, I think that may have been, I don't remember if I think that may have been more practice than a requirement. Yes, member neighbors, you have some information.
I think it depends. There are the individual rules of any commission, but Robert's Rules of Order has its own reading on the summarizing and how those are going to be put in the meeting. And so the training that they're getting may be that they're just using Robert's Rules of Order and that's what they're going to be using as their standard, right? Which
right.
Is, okay.
Yeah. Okay. So
could I put something in there? And once again, 150 words is doable, but it's 100 and 150 pages that become burdensome.
Yeah. I hear what you're saying. Yes, and that's why
Can I add something? Yeah.
Okay, I'm hearing lots of voices right now. Here's what I'm going to do, because I'm going to give everybody a chance to speak. We've heard from Mr. Greer and Mr. Hillier. I'm going to give Ms. Gray a chance to speak, and then I will circle back with Mr. Gray and Mr. Hillier. So, excuse me, Mr. Greer and Mr. Hillier. Ms. Gray.
Okay. So the thing is, it makes me question when access, where's the line of when access becomes harassment? If there's no real purpose to what the access you want. I understand that we're giving access to the public, but the time that it takes for all of these accusations and the effort of the back and forth is very tiring and stressful, and it raises the anxiety level because it's unfamiliar for me, and I've never seen the people who are in this virtual meeting, so it makes me feel more unsafe. That to think that one day I'm going to have to be in public in person with people who have conduct that is uncivilized. I'll just say in a general statement, and I just wanted to reiterate, safety is of the most importance. And so I've even talked to my employers to make sure that if we do go in person, things are different, and it's some kind of precaution, prevention measures taken. Because it seems like this is accelerating daily. And around the time when it's time for our posting, we get these emails and these accusations, and it's like I wake up to it every morning. It's like, it's a lot. I just wanted to speak to how it really feels. But in the time I've been there, we've only been working to improve things and to work collectively as a team. And I can't see, I know that all teams are not perfect in the beginning. Everybody has their own foundation for who they are. However, we have to figure out how to work together. And even with the public, we want to work with the public. But 150 words is a lot.
Okay, Ms. Gray, thank you for your comments. I appreciate this, that you sharing this with us. I want to be clear, when I was saying 150 words, that I did not mean summarizing. And you know what, before I go further on this, I want to say I'm going to look into where I'm remembering this from. Okay. And I think it was related to the Board of Supervisors, now that we're talking about it a little bit more, and that they had set a policy about if people wanted to and Mr. Young can correct me where I'm wrong on this, but if people wanted to submit written public comment, that they were allowed to submit up to 150 words. That would be included then, and I see Ms. Lejay nodding, that would be included then at the end of the minutes when those were created for the meeting.
Hi, this is
I don't
Mr.
want to.
Young.
Yes, Mr. Young, please go ahead.
I'd like to make the clarification. I think there's some misunderstanding going on.
Mm-hmm.
Members of the public are allowed to submit a summary of their own public comment that they provided in person for inclusion into the minutes. In terms of location in minutes, that's various organization debates where it's placed. I think the other part of it that people are talking about are written submissions of documents, such as correspondence and supporting documents and so forth, that in general become part of the file because it's related to it, but it's not a summary of the public comment. And there's nothing related to 150 words in regards to that.
Right.
That's a submission of documents.
Yes, submission of documents. And so what I'd like to do a little bit of research on is what the requirements are. I guess, and in this situation, we're more concerned about the submission of documents to be included with the file and what the opportunities and restrictions that might be tied to that, so that we can be clear for all parties involved what they should be expecting. So if somebody submits a large quantity of documents, what they can reasonably expect will be done with those documents. and for those receiving such documents, that they have a clear understanding of what they would be expected to do with them.
This is
Make sense?
again.
Yes.
I believe that various organizations develop their own policies. As the task force itself states, unless we get it a certain amount of days before the meeting, the task force can't consider it. And the Board of Supervisors itself, we don't set a timeline, but we don't have an expectation that it'll be placed online immediately. So I think this may be a policy call for the Behavioral Health Commission to make their own policy on what they can do and what can't be done. That's just my own personal opinion and not a evaluation of law.
Yeah, I want to make sure, and actually I'm going to direct this to my committee members here. I want to make sure that we're keeping in mind things that relate to the Sunshine Ordinance and the California Public Records Act, and not getting too far into the weeds on practices of different departments or commissions or agencies. You know, I obviously have the most experience with the Sunshine Ordinance Task Force, and I don't want to misinterpret what we do as the requirement for what must be done. And I see member neighbors nodding. Do you have any recommendations on regarding this? I mean, I as we said, we're not going to wrap this all up today. We can look into it more, and if you have any comment to offer about this, I'd appreciate it.
I'm glad to hear there's training going on, and I'm assuming that training is going to set the behavioral health commission up for success. I do want to say also, I know, Mr. Greer, I'm hearing you like go through the things and you kept saying they. It's really us too. I mean, we're all a subset of the SOTF overall. So these bullet items that you have here, these are our items in the sense that, you know, these are the things that we kind of deemed as really important for you to work on. But those, as Chair LaHood is saying, the reason they're important is because then you're in compliance with the ordinance. You're not going to have anybody else making complaints about you, or they're not just things that we think you need to improve on just because they're things that every commission and every body in the city is responsible for doing. So, you know, I think it's like you're getting that. You could I think you'll recognize some of these things as they come across in your training. Ms. Gray, also, you'll be like, I remember we were talking about that, and they'll become even more clear in that way. So I think it's just going to be a process that's going to take a little bit of time. And I would urge, you know, I would urge anyone who's participating in that commission to support that learning, to have a little bit of patience, and you know that there is improvements. There is improvement since we first saw this matter, for sure. I know Mr. Greer, first time we talked to him, there were many things of these things that he didn't even know what they were about, and now he's you know, an expert on them. So
Thank you.
Thank you, Miss Neighbors.
So
Can I make my comment now?
Sure, we'll take a comment.
Okay, thank you. Okay, so to clear up the 150 word thing, that is in section 67.16 regarding minutes. And that section of the Sunshine Ordinance does not apply to the Behavioral Health Commission or the Sunshine Ordinance Task Force. It only applies to charter boards and commissions. So, for example, it applies to the Health Commission, but BHC is not a charter board of commission, and so the 150 word summary does not have to be accepted by them or put in their minutes. That's not what I'm complaining about. What I'm complaining about is 67.9A, which is supportive documents, and 67.7B, clear descriptions. I forgot to mention 67.7B in my introduction, but what they're supposed to do is if they receive a document to be distributed to all the commissioners regarding something anticipated to be discussed, before they post the agenda, they're supposed to put a notation on the item saying, correspondence received, see this file or whatever, some kind of reference to it in the item. That's 67.7B. 67.9A says, regardless of when it's received, it needs to be on the website to the extent possible. So that's the problem we're having. It's not a 150-word summary issue, and the reason it's a policy with SOTF, even though the law doesn't apply to SOTF, is that you have it in your bylaws that if a member of the public submits a 150-word summary of their public comment, it needs to go verbatim into the minutes. Back to you, Madam Chair.
Thank you, Mr. Hillier, for identifying the 67.16. So the good news is Behavioral Health Commission does not need to worry about that one. That was actually very helpful. So I do appreciate that. It is getting on, we are at 8:45 p.m. I know you've all been here for a long time. We did not, as I said before, we wanted to get started on this discussion. Members, unless anyone has a particular motion, well, let's think about this. What I'd like to do is to follow up again in October, especially since we know that there's going to be the new website in place, which we hope will facilitate easy posting of clear agendas 72 hours in advance of the meeting, providing clear descriptions with all of the supporting documents online, and the posting of supplementary documents for the meeting on the internet. I'm hoping that when we come back in October, we'll be able to review the changes and hear back from Ms. Gray and Mr. Greer that things are working smoothly. That is not to say that we're saying you don't have to do anything between now and then, because we would like you to use your current website to the best of your abilities to comply with all of these things now. Also, to make sure that there is public comment at the right point on the agenda for each item. And it does, from what you said, the recent training you got may help you make sure that you're getting the comments in at the right time. And, we'd love to hear back about that as well. Members, is there anything else that we want to ask for, that will help us when we come back together in October? And also, I will say, is there anything that we can do? If you have any questions for us or anything that we can do to support you in, in helping to support what you're doing with your agendas, or any questions you might have for us regarding this initiative.
If any information does come to your attention about the things that we discussed thus far, if you could forward that to me, that would be helpful.
We can do that. And Ms. Leger is great about making sure that if there's ongoing conversation regarding items that, parties are informed and receive documents that they should be receiving. And yes, we can make sure of that.
And I just want to double check also, it sounds like that Ms. Gray has the support within her own department and from her own supervisors that she needs in order to feel safe in her role and in the workplace, but want to double check to ensure that that there's nothing that we're doing or that you need us to do to support that.
Thank you. Thank you so much.
Okay, just let us know if there's something. Okay.
Thank you. I appreciate that.
Okay, and members, and thank you everyone for being here and being part of this discussion. I know it's not always easy, but I hope that this can be productive and we can, we can help all parties involved. So I'm wondering at this point if we need to I will take public comment regardless, but I'm wondering if we need to take a motion or if we want to just continue this to the call of the chair and with the intention, it sounds, what I'm hearing from the Behavioral Health Commission, they are continuing to work on these items that we asked them to work on. I expect that Mr. Hillier will also be following what they're doing, and I would expect that we may hear from him between now and the next meeting with his thoughts on their progress. And I would like to put this on the agenda again for October so we can review progress that's being made and go from there. Do we need a motion, or can we continue this to the call of the chair?
Someone has
The motion would be to continue it to the call of the chair.
Would someone like to make a motion to continue this to the call of the chair?
This is Member Neighbors. I'll move that we continue this matter to the call of the chair.
Do I have a second?
Seconded.
Okay, seconded by Member Wong. We'd like to open this up for public comment. Is there anyone, any members of the public who'd like to make comment on this discussion and on this motion? If you are on the phone, you can press *3 to join the queue. If you are on WebEx, raise your hand. And Mr. Young will let us know who is in line wishing to make comment on this matter.
We have at least one member of the public. I will unmute him now.
Thank you, Chair Hood.
One moment, and I'm sorry, I missed this on an earlier one. Ms. Leger, will you let us know when you're ready with the timer?
I'm ready.
Please go ahead.
Yes,
Thank you.
I would just like to offer everybody to take a deep breath. That's an awful lot to take in. And first, I come here with all transparency. First, I am a consumer. Secondly, I am a mental health advocate. And thirdly, I serve on the commission. I am here as an independent. I have been on watch almost every meeting for this last 7 years. I have not seen the Behavioral Health Board was under investigation. I have sat in all of their meetings. They only did 2 site visits. They had a very undiverse board. They went absent during COVID. I don't see any of that torn apart, ripped apart. Even on this line, you heard criminal charges. You're hearing someone being afraid of inundated things. And when it happens to other boards, commissions, they have the structure within to say, no, you're going to do it this way, present it this way. The Behavioral Health Commission is a diverse population. It is the most popular diversity it has been in the last 20 years or of its existence. And please, I do not want to be corrected verbatim on my public comment. It's intimidating. I have brought, as an outsider, I have just become a commissioner. I have brought groups there to bring their voices, and they are intimidated because every comment, public comment, is a correction or in a form. It depends. You're dealing with people with mental health challenges that are coming to a place or illnesses to speak, to voice a community concern, and the intimidation towards the commission has a ripple effect. And I know that you want to look at percentages and keep it correct on the Sunshine Ordinance Task Force. But when you're working with now, why did you not get inundated with all of these complaints prior to 2020? And we're now looking at a new era, a new history, and a growing curve. And yet it's being given these criminal charges, these slanders. And I'm just like, whoa, how does that serve the public? And how are you serving us by just data? Where's that learning curve? And when does it become kind of like every second, or everything is corrected to the point where there is actually no progress and levels of intimidation to the purpose that of the public that we need to serve? And it's very difficult to get people to come to a public mental health come publicly to express themselves and their fears or their concerns, and especially in a time when our mental health and substance abuse is at its highest levels in the city. We need to be a very efficient working commission, and to eliminate this kind of back and forth and really
Yes.
give us some time to maybe have a curving way where we can just
I'm so sorry.
Thank you.
You've gone over your time, but thank you for your comments. We appreciate hearing from you. Mr. Young, can you let us know who's next in line?
Yes. Everyone has been unmuted, so if there's anybody else who would like to give public comment, if you can announce your name, it would be appreciated.
Okay. I heard Mr. Sullivan. Ms. Leger, could you let him know when you're ready with the timer?
Are you ready, Mr. Sullivan?
Yes.
Go ahead.
So I just want to reemphasize section 67.7b. And it's the description of the agenda, and it shall refer to any explanatory documents that have been provided to the policy body in connection with an agenda item. Such correspondence or reports and such documents shall be posted adjacent to the agenda, or if the documents are more than 1 page in length, made available for public inspection and copy at a location indicated on the agenda during normal office hours. So any means that all of them have to be put into the packet of the agenda. And it doesn't matter who that person comes from. It doesn't matter how long it is. It makes no difference. And so we really need to follow the law. And we need to, and it's not what other committees do. Everyone needs to follow the law, and we can't be lax about it, which is you talk about my frustration. My frustration is with the Sunshine Ordinance Task Force in not enforcing the laws. And it's not with Mr. Steinberg. I know who he is. But the thing is just in this meeting alone, I told you there were missing documents, explanatory documents in both item 7 and item 8. And you still continued on with the agenda. And that's all I got to say. I mean, I'm not going to, file a Sunshine complaint against Sunshine. That wouldn't pass for that. But I'm just pointing it out. Thank you for your time.
Thank you for your comments. We do appreciate them. Mr. Young, is there anyone else waiting to give public comment?
I believe that completes public comment. Yes.
Okay. I don't know if I should respond to that last comment or if we should just keep going.
Well, I can make a statement if you want me to be public.
No. Actually, hold on one moment. I'm thinking about this with regard to our committee members. You know what? No, I should not, because we just took public comment on a motion, and we need to members. Is there anything regarding this motion that you would like to say, or shall we take the vote? Okay. Mrs. J, please call the vote.
Member Neighbors?
Aye.
Member Neighbors, aye. Member Wong?
Aye.
Member Wong, aye. Chair LaHood?
Aye.
Chair LaHood, aye. Moved by Member Neighbors, seconded by Member Wong to continue the matter to the call of the chair.
Okay, and just to clarify so that everyone involved in this understands, the chair is calling for this. I would like for this to be added to the October agenda. Now, that is 2 months out, so I will confirm this with Ms. Leger and make sure that will be on the agenda. She will get in touch with you in advance. You have the opportunity to add documents for the Behavioral Health Commission, anything that supports work that you've done for Mr. Hillier or any member of the public who has other supporting documents they would like to include on the item, which we expect to have on the October agenda. I welcome you to do that. Thank you, everyone, for coming today. Thank you, Ms. Gray, Mr. Greer, Mr. Hillier. We appreciate your participation, and to our public commenters, we appreciate your comments. Thank you for being part of this.
Thank you for listening. Appreciate it.
You're welcome.
Yes, thank you.
You're welcome. Thanks. I do want to respond to, and if Mr. Sullivan, I hope Mr. Sullivan is still here. I want to respond to his comment regarding something he brought up early in the meeting, and then regarding items 7 and 8. I had expected, you know what? I had expected that concerns would have been brought up when those items were brought up. That's what I thought was happening. And since they were not, we proceeded. So I'm sorry if there was a misunderstanding about that. Please call the next item.
Item number 10, announcements, comments, questions, and future agenda items by members of the Compliance and Amendments Committee.
Do we have any announcements, comments, questions, or future agenda items by members of this committee?
Speak up, ladies.
I will bring one that we are planning to have on our next agenda, and that is there's some proposals for possible amendments to the Sunshine Ordinance. We are not going to discuss these now. But there is a plan to have that on the agenda for the October Compliance and Amendments Committee meeting. Does anyone have anything else that they would like us to add? Any members of this committee that you would like us to add for discussion in October or in a future meeting? If it's something that's not urgent, we can always put it on an agenda further out.
Can I clarify that? Are you saying that we will be meeting with San Franciscans for Sunshine, or they will be making a presentation?
Yes. So anything else, or should I open up for public comment on?
You did good. You know, Liza's
I'm sorry
right now. She's all upset because she.
I'm sorry. You know what? I'm hearing. Hold on. I'm hearing people talking who I think are having a conversation that they don't mean to be recorded. So if you were speaking, okay.
I have muted everybody.
Okay. Thank you. Thank you very much. Mr. Young, we will open this up for public comment. If anyone has public comment on the item that we have proposed, that I have proposed that will be on the next agenda, but this is not an invitation for members of the public to propose items. So if we have any public comment, we welcome that now.
We have one hand raised. I will unmute them at this time.
Thank you. And please wait for Ms. Leger to let you know when she's ready with the timer. Thank you.
May I have your name, please?
Sullivan.
Are you ready, sir?
Yes.
Go ahead.
I mean, I'm not mad. I consider it a running conversation on future agenda. Anything that I bring up. So I understand this communication. I just, want stricter following of law. Yeah, because everyone understands what's written down or on the agenda. And if we don't follow that, then it just adds confusion and stuff. But I understand we're still evolving and learning about what the Sunshine Ordinance, the CPRA, and all that. It always changes. It's always an evolving agenda conversation. And it's just a little frustrating every now and then, but not anger. All right. Thank you for your time.
Thank you for your comments. We appreciate them. Mr. Young, is there anyone else in queue to make public comment on item number 10?
There's no additional public comment.
Okay. Ms. Leger, please call the next item.
Item number 11, adjournment. I have 9:04.
Do we have a motion to adjourn?
So moved. This is member Wong.
Do we have a second?
Seconded. Neighbors.
Let's take this by acclamation. Meeting adjourned. Thank you, everyone. This was a good meeting. I thought it was very productive, and thank you to all of our all of the parties and members of the public. We appreciate you being here.